Yeah, there is.
Good afternoon, one and all present here. Please. This lecture is kindly sponsored by Advocate Karthik Ashok and Siddharth Baldev. It is an honor to introduce Mr. Jawahar Trivedi. Mr. Jawahar Trivedi is our esteemed speaker for today's special lecture. Mr. Trivedi is the Vice President of UFO Movies India Limited, bringing over 2 decades of experience in the legal intricacies of media and entertainment. His career spans influential roles at B4U Broadband, Hungama Digital Media, and PVR Pictures, making him a leading voice in the industry. An accomplished author and legal expert, Mr. Trivedi holds a Master of Laws and specialized training in arbitration law. His unique blend of industry experience and legal acumen promises to offer valuable insights into the challenges and strategies. Join me in welcoming Mr. Jawahar Trivedi.
Good afternoon, my dear friends, ladies and gentlemen. At the outset, let me thank you for inviting me here to address you. It is always a pleasure to speak to bright young legal minds who are the future of our legal profession. Before starting this topic, I would like to give a short disclaimer, that this topic itself is so vast that, I will be just going through this topic. If there is some thing, which you want to discuss more in detail, please feel free to connect with me online, because we have to maintain the limitation of time. So I'll just, I will be covering this topic, but if there's anything you need to know more in detail, please feel free to get in touch online. Okay, so we start with the first part. The first part deals with understanding the content distribution industry and what legal practices are there in the content distribution industry. So before I start with the industrial knowledge, I would first like to share with you some concepts of copyright law. So there are 3 important things that you must know about copyright law. The first thing is that copyright itself is a bundle of rights. See, each and every word which is highlighted is important. Copyright is a bundle of rights available to the author of an original work. So the word copyright itself, if you ask me, is a misnomer. It is not a single right. It is not one right. There are several rights included under the umbrella of copyrights. It is available to the author. So who is an author is also defined under the definitions clause of the Copyright Act. I am not going much in detail over here. Now, the work should be original. When I say the work should be original, does it mean that the work should have never existed before? Now, we all know that there are 2-3 TV serials based on the epic Ramayana. Each of them will have copyright. So originality means originality of expression. You just keep that in mind. And the most important word over here is work. So whatever is considered as a work under copyright law, only that thing can have copyright. If a thing is not work as defined under Copyright Act, it is not capable of having copyright. The second thing which you must keep in mind is that it is a statutory right. Copyright is a statutory right. It is not a fundamental right, or it is not an equitable right. What do I mean when I say that it's a statutory right? The limitations of copyright are circumscribed by the statute. Okay, so copyright cannot extend beyond what the copyright says it is. The Copyright Act says it is. So keep this in mind. So to give you an example, in India, the term of copyright is 60 years. You create a work, you will enjoy the copyright for the next 60 years. When the 61st year starts, copyright no longer exists. It is gone. So you cannot say that, no, I want copyright for 100 years. It's not possible. Right? So these are the 3 very important things. First thing, it's a bundle of rights. Second thing, it's a statutory right. And third thing, whatever is the thing in which you are claiming copyright should qualify as a work under the Copyright Act. Now, one more thing which I want to bring to your notice. Now, when you ask this question, that what is the purpose of having copyright? People will say it is to protect the creative people and their interests. Yes, it is. But the greater purpose is that by giving protection to the creative people, you are inducing them to provide the benefits of their creative work to the public at large. So if there is no protection available, these creative people will not publish their works. They will be afraid. They will say, what is the protection? Tomorrow anyone can copy it. I have no remedy. So the idea is that give them the encouragement that yes, you will be protected, share your creativity, let it benefit the society as a whole. So keep this in mind. And one, since most of you, I don't know how many of you are currently pursuing copyright, but if you really want to understand what is copyright, Section 13 and Section 14 are the most important sections. And I call these sections the heart of copyright law. Okay. Section 13 says works in which copyright subsists. Section 14 says what is the meaning of copyright. And as I have mentioned before, copyright is a statutory right. So you must know, if you want to do something under the Copyright Act, you must know what are the contents of these two sections. Otherwise, there is no point. Now, I will talk a little bit about the content distribution industry itself. Okay. So in content distribution industry, there is a maxim that content is the king, and which is very true. Whether you are running a TV channel, or you are running a OTT platform, or you are running an online storefront for selling vast content, you require content. Okay, just as a shopkeeper cannot do business without goods, a media house cannot do business without content. Another requirement, so content includes what? So we usually, when we talk of content, usually what comes to our mind is audiovisual content, but it's not just audiovisual content. It can be audio content, stills, images, wallpapers, clips, RBTs, etc. So it has a very wide connotation. Now, there is one thing, which we need to keep in mind, that the nature of content business keeps on changing. Content has a very, very strong correlation with technology. As the technology evolves, the type of content and the manner in which content is distributed also changes. So let me give you some example to drive home this point. In early 2000s, when mobile telephony started penetrating in India, the VAS industry, VAS, VAS, value added services industry, started taking root. People started, so the entrepreneurs, the media houses, they started offering content in the form of wallpapers, stills, RBTs, ringback tones, ringtunes. Okay. Around the middle of the first decade of this century, somewhere in 2004-2005, multimedia phones came into existence. Now these multimedia phones were much superior than the earlier version of the phones. Earlier you had those candy bar phones with a very limited small area of display. Multimedia phones offered you a better experience. So VAS content evolved more. Now they started offering multicolored content. So from text you moved to images. After 2010, and with the advent of 3G and 4G, content streaming became very stable. So now, earlier, in the days of 2G, if you tried to watch a YouTube video, your video would start buffering. It would not play continuously. You would get frustrated watching it. And finally, you would abandon. You would say, "Jaane to nahi dekhna hai online." But with 3G, 4G coming in picture, YouTube gained prominence. People started building YouTube channels. Media houses had their own companies like T-Series, YRF. They started having their own YouTube channels. Even today, they are selling movies on subscription basis, as well as you can purchase it to watch it online. And the most important development which happened was that the prices of data crashed. When Reliance launched the Jio offering, they gave 4G data for free. I remember myself in 2015, I used to pay 250 rupees for 1 GB of data. But after Jio was launched, the data prices crashed to around 10 to 20 rupees a GB. So data became more accessible. There was more stability in streaming. OTT platforms started developing because finally data consumption was happening and it was easy to access the content at a very reasonable rate. Point I am trying to make here is, as technology has evolved, the type of content that is being consumed has changed. There is one more very interesting thing that I want to share with you. As social media platforms developed, the patterns of content consumption changed. So from viewers, the consumers became choosers. In the early days of internet, you had a very limited choice of what you could watch and see. But today, in this age of social media, you actually decide you are not just consuming content, you are creating content. You are choosing what you want to see. You are sharing, suppose if there is a party, which has gone very well, and you just want to put up the highlights in the form of Instagram reel, you can do that. So now, the consumer has turned into the creator. That is the difference which has been brought about by technology and the mode and manner in which content is being distributed. Okay, so coming back to the content distribution industry, cinematograph, film, and sound recordings are recognized as work under the Copyright Act. So as I mentioned before, whatever is work under the Copyright Act can only have copyright. If it is not work, it does not have copyright, as simple as that. So for the purpose of cinematograph, films, and sound recordings, producer is considered as the author. So producer is actually the owner of copyright in cinematograph, film, and sound recordings. Now, let us understand one thing, that the nature of content business is very different from the other type of commodities which are there. Now, what do I mean by this? See, if you go to buy a flat from a builder, the builder has to sell the entire flat to you. He can't say, I will sell living room to Mr. A, bedroom to Mr. B, kitchen to Mr. C. No, that's not possible. He has to sell the entire product to one person. Okay, all the rights come to one person. But like I said in the beginning, copyright is a bundle of rights. So it is possible for him to segregate each and every right and sell it to separate people. Now, what are the kinds of rights, or what rights are there? What am I talking about? So basically, these are the rights, the different kind of rights that are there in content. Okay, theatrical, we all know theatrical. If you want to show film in a theater, you need theatrical rights. Then there is non-theatrical. Non-theatrical is where, suppose like you have this auditorium, you want to see a film over here. So it will be a non-theatrical performance. Then, of course, satellite TV, cable TV, pay-per-view, airline ship, hotel rights. These are called ancillary rights, airline ship and hotel rights. So, if you are flying, say, on long distance flights, you see this more often, that if you access the IFE, the in-flight entertainment system, you will find some Hindi songs, you will find some Hindi movies, fight and Hindi movies. So all this are called airline rights. If you are going on a cruise, these films are offered on your entertainment system, then they are ship rights. Okay. Then there's rights of physical devices like your CD, DVD, and Blu-ray. So if you see, there are so many rights, and there can be even more. And one thing I can guarantee you, that the number of rights will only go on increasing as technology evolves. So to give you another thing, to give you another perspective, earlier, in the agreements which we used to draft, I'm talking about 2010, 2011, we just used to write internet rights. Okay, so if I wanted to grant internet rights, I just used to write internet rights. Now what has happened is, people have seen that even in the internet, there are different segments where you can monetize the content. Which are these segments? You have YouTube, you have Apple iTunes stores, you have Android market, then you have OTT platforms. So now even in the internet rights, there is this division which has come about. So now each of these platforms, the right to exploit content on each of these platforms is by itself a separate right. So see, this is how, how the technology has evolved and how the number of rights has grown. So from one internet rights, it has split up into several rights. Okay. So you can have the vast content rights, prequel rights, sequel rights. So if a film is very successful, someone might want to make a prequel or sequel. Or say a film in Tamil language is very successful, I want to make it as Hindi. I will have to take the remake rights. Then there are dubbing rights, subtitling rights. So there are a number of rights. And as I said, these rights will go on increasing. These rights represent the opportunity for monetization. Okay, now coming to the content, now coming to the agreement bit. We have spoken about the content industry, we have spoken about rights. Now this is something of interest to you as a lawyer. When I say you can exploit the rights, it means you can assign the rights to someone. You can permit someone to use that particular right in respect of the film. So if you are giving it to a satellite channel, you are giving the right to satellite channel to broadcast it on their satellite TV system. Okay. So how do you do that? As a lawyer, now believe me, as a lawyer, when we look at a film, there is intensive documentation required right from the stage of production till the stage of distribution. So just to share my experience with you, in the film production stage, when a film is produced, there are 3 stages. One is the pre-production, there is production, and there is post-production. In pre-production, you sign up your story writer, your principal cast, your director, your executive producer. In the production stage, you actually enter into agreement with the service providers, like location owners, then editors, costume designers. And finally, when the film is, the shooting is over, the principal photography is done, then comes the post-production stage. So you have your VFX guys, then your, the dubbing guys and all. So these are the so there's intensive paperwork required. Once your product is ready, then you actually have to sell your product, and that is where content distribution comes in. So once your product is ready and finally finished, then you go to the distributor and tell him, boss, this is what I have to offer. And at that stage, content distribution agreements come into picture, assignment agreements come into picture. So there are now again, here there are 2 things. These are the statutory requisites. So first, the requisites are provided for in section 19 of the Act. Okay, please read to section 19 if you, it will be very informative and useful for you. The first requisite is it must be in writing and signed by the assigner or his agent. In other words, you cannot have oral assignment of copyright. I can't say, okay, I am assigning you this film, and end of the story. That doesn't work. It should be in writing and it should be signed by the assigner or his agent. The second and the most important requisite is that there must be identification of work. What do I mean by identification? Now, those of you who follow the film industry, you know that there are 3 films by the name of Aankhein. 3 films are different, and all these 3 films have different star cast and different directors. So if I just write in the agreement the film Aankhein is assigned, it doesn't identify sufficiently. You will have to mention the name of the star cast and the director. Okay, that's what we do practically. Then term and territory, very, very important. Okay, so sometimes it happens your business team calls up, boss 10 minute में agreement चाहिए, producer जा रहा है out of India, जाएगा तो 2 महीने बाद आएगा, जल्दी से बना के दो. It happens very frequently in the media industry. And suppose you forget to write the term, what happens? Can anyone tell me what will happen if in an assignment agreement you forget to write the term? Anyone? No. The copyright itself can never continue forever. answers? No?
Sir, term is required to distinguish between license and assignment.
No. See, you are giving an assignment to someone and you forget to mention number of years. तो क्या करोगे? What will be the term? कुछ तो होगा ना? So that lady over there said it's perpetual. ऐसा होगा तो जॉब चला गया समझो. So it is 5 years. If you forget to write the term, it is 5 years. Okay. It will come to end after 5 years. Your assignment will end after 5 years if you forget to write the term. अच्छा, what happens if you forget to write the territory? क्या होगा? Territory लिखना पड़ेगा ना कि you can exploit only in this territory करके. तुम लिखना भूल गए, तो क्या होगा? हाँ? वो एक्ट में लिखा है, स्टैट्यूटरी राइट है, तो 5 साल के बाद हो गया. गवर्नमेंट ने बोला कोई कुछ नहीं कर सकता. So what happens if you forget to write the territory? Bright legal minds, come on. Say the term, if you forget to write the territory, it will be India. Only in India. तो आपने वर्ल्ड का भी पैसा भरा होगा, तो भी आपको इंडिया में ही अब चला सकते हो. If you forget to write. See, this is how important it is. Nowadays, you know, there's a trend. मीडिया हाउसेज लाइक टी सीरीज वो टेरिटरी में मालूम क्या लिखते हैं? इंडिया और वर्ल्ड नहीं लिखते, यूनिवर्स लिखते हैं. बिकॉज वो आउट स्टेशन में जाता है ना, वो भी स्पेस टूरिज्म, दे वांट टू यूज इट देयर आल्सो. दैट इज द ट्रेंड. एनीवेज, कमिंग बैक. ओके, रॉयल्टी एंड अदर कंसिडरेशन. व्हाट कंसिडरेशन यू आर पेइंग फॉर acquiring the rights, you have to write. What royalty you are going to pay to the authors, you have to write. Okay? Now, what I'm going to say is very, very, very important, super important. Rights do not lapse if assigned rights are not exercised within 1 year of assignment. Please read section 19 subsection 4 of the Copyright Act. और कभी अगर एग्रीमेंट करोगे असाइनमेंट का तो ये टर्म डालना मत भूलना, क्योंकि अगर 1 साल तक आपने कंटेंट एक्वायर करने का नहीं चलाया तो आपका राइट लैप्स हो जाएगा. इट इज अ प्रोविजन ऑफ लॉ. अनलेस यू मेंशन कॉन्ट्ररी टू दैट नो इट विल नॉट लैप्स, it lapses. इस बात को हमेशा ध्यान रखना. The first thing I do when I draft the agreement is I put this condition. Because sometimes when we acquire movies, you acquire a lot of 200, 300 movies. 100, 300 मूवी कोई चलाएगा नहीं 1 साल में. तो अगर ये डालना तुम भूल गए तो राइट गया और आपका पैसा भी गया. And another thing is that you have to keep in mind is that if there is an assignment, कभी कभी there are authors, you know, who have assigned their rights of collection of royalty to copyright societies, जैसे IPRS है. So you cannot include any term which is contrary to the terms of assignment made to IPRS. So you need to be very clear. उसको पूछना पड़ता है ऑथर को, भाई तुम IPRS का रजिस्टर्ड हो क्या? वो हम representation लेते हैं कि I have not inserted any term which is contrary to the terms of that agreement. That is very important. Okay. Now some practical aspects. ये तो मैंने तुमको एक्ट का बताया कि एक्ट में ये रिक्वायरमेंट है, बट देयर इज समथिंग मोर. सो दिस व्हाट आई एम टेलिंग यू इज फ्रॉम माय प्रैक्टिकल एक्सपीरियंस. फर्स्ट ऑफ ऑल, योर definitions have to be super clear. What you mean by rights. Suppose you don't want to give OTT rights, then your definition must state internet rights will include the rights to exploit content on internet except through OTT platforms. वो आना चाहिए. If you forget to write it, tomorrow there will be a dispute. You will in your mind think OTT तो नहीं दिया है मैंने. जिसने एक्वायर किया वो सोचेगा मेरे पास OTT rights है. You go and sell it to some other OTT guy. This guy will file a case against you. The person who has purchased rights from you will say, now you indemnify me because he has made me also a party. Then second, and the most important thing, when you become a business lawyer, you have to understand law as well as business. If you are a litigation lawyer, understanding of law is enough. But when you become a business lawyer, you have to understand the law as well as business. So commercial construct of the deal becomes very important. When you are acquiring content, it's a matter of crores of rupees. So you have to understand what is the commercial construct. So एक होता है flat deal. Flat deal is where you just pay the money to the producer. Producer does not care whether you make a profit or loss. If you make a loss, it's your problem. If you make a profit, कोई बात नहीं, अच्छी बात है. So that is called as a flat deal. Then there is something called as a minimum guarantee. Minimum guarantee क्या होता है? Minimum guarantee is where the producer assures the distributor that, okay, you pay me 10 lakhs, I assure you will at least recover 10 lakhs plus your expenses. And if there is any shortfall, instead of 10 lakhs, he recovers only 8 lakhs. The producer will have to pay back the money to that extent of shortfall to the distributor. Okay. Then there is something called as a revenue share. In the revenue share, there is no upfront payment. Whatever revenue will be generated from the distribution of content, it will be shared between the parties. Okay. Now there can be other restrictions which you need to be careful about. That content, now sometimes you will acquire content. The person giving you the rights will say, okay, I am giving you content, but you cannot run it on your free YouTube channel. Now, almost every media house today has a free YouTube channel. तो वो बोलेगा आप उस पर नहीं कर सकते, but you can give it as a SVOD. अगर वो subscription base पे लेता है तो you can give it, but you can't give it for free. Or on AVOD. AVOD is advertisement video on demand. What your YouTube is. Okay. Then there are holdbacks. So कैसे होता है कि you cannot just start exploiting. If it's especially for Hollywood films, for you sign the agreement, but 18 months after it is released in US, you will get right to release in India. So that is a window that they keep. Okay. Then number of runs. Abhi, when you acquire films for satellite TV, they will not, you may have the rights, he may have assigned the rights, but he will say, you cannot show this film more than once a month. If it's because he doesn't want it to become very commonplace. So if it's a very premium film, he will say, you can't show it more than once a month. So you get total number of 12 runs in a year. So if you have bought it for 10 years, you can show it 120 times subject to once a month. So ये सब चीजें ध्यान में रखनी. What? See, these are practical things because when you enter these things in your right management software, your scheduling team gets that message that ये film available है, but you need to mention that it's available only once a month. Otherwise, उसने 2-3 बार चला दिया एक महीने में अच्छी film समझ के, it will be exceeding the license and it amounts to infringement of copyright. And infringement of copyright is a criminal offense. Your directors will face trouble. So all these things you need to keep in mind. These are all practical aspects I am telling you. Copyright Act में कहीं नहीं लिखा हुआ है. ये मेरा industry experience है. Then if you are distributing songs, so there used to be earlier, अभी तो people allow the full streaming of the song, but earlier there used to be a song sampling limit. So आपके platform पे user आया, उसने song का button press किया. If it runs for 30 seconds, it is counted as one stream. But if it finishes before 30 seconds, suppose 30 seconds उसने पहले ही बंद कर दिया, it is free. Now, for one stream, they charge 20 पैसा. 20 पैसा आपको लगेगा बहुत minuscule amount है. But अगर millions of stream हो गए, तो सोचो क्या होगा? You know, you will, there will be a payout. So you need to be aware that what is the amount of, the sampling limit. If I am acquiring content, I will always ask for a higher sampling limit. Because I want that, I don't want to make very large payouts to the labels. Now, this is something which is super important. Public notice of acquisition. जब आप content लेते हो, तो there are some magazines which are called trade magazines. वो film trade के magazines होते हैं. उसमें सिर्फ entertainment के ही खबरें तो नहीं बोलूँगा, but commercial खबरें छपती है. इसने यहाँ rights लिया, इसने ये किया करके. So when we acquire films, as a matter of precaution, we issue a public notice in such trade magazines. We tell them that, and that notice is very detailed. So we give the name of the film, name of the star cast. We say that we have acquired these rights. If anyone has a problem, please come within 15 days or 30 days and inform us. Now, what happens is this clause is linked to the payment. So when you acquire films from a producer, don't make entire payment upfront. We say that we will make 25 or 50% payment. We will give the notice. If there is no objection for 30 days, then we'll make the balance payment. Why? Because if you make the whole payment upfront, you give the notice or objection aa gaya, your money is stuck. Then unless the issue is resolved for 4-5 years, वो आपका पैसा वहीं पड़ा रहेगा. So this is also one very practical thing. So मैं आपको बता रहा हूँ. When I was working for Before You, we bought some South Indian dub films, and we made payment of only 30%. And we gave the public notice, and immediately there was an objection from one leading media house from Hyderabad that these rights are mine. How can you acquire these rights? And then, finally, as it happens in the media industry, we got some alternate films, but it is very important that you don't make the whole payment upfront. So this is a very practical thing. ये Copyright Act में नहीं लिखा हुआ है, but ये practice में होता है. Okay, and the most important thing, content specification. So when you are running, see you, ठीक है आपने agreement तो कर लिया, सब कर लिया, लेकिन how will you exploit the film? Content चाहिए ना हाथ में. उसका क्या बोलते हैं? You need that physical content in hand. Now you are running a HD channel. कोई पुराने film है, and this has happened to us. We bought some old films. We started a service called Before You Kadak, which was supposed to be HD films, and this film content which came to us was very grainy, because at that time there was no concept of HD content. So then finally we had to cancel the deal. Films were very popular, no doubt. वो 60s 70s के अच्छे थे, लेकिन उनके पास कंटेंट नहीं था. So you have to ensure that you write the content specifications in the agreement. Otherwise tomorrow he will say, oh, I thought you wanted HD content. तुमने कहाँ बोला था HD content चाहिए करके. So see, these are all practical things. And you must provide a delivery timeline. So again, you link some payment to delivery. Don't make the whole payment upfront. You say you deliver the content, it should be satisfactory, then I'll make the balance payment to you. Then QC, quality check. Quality check is very important. Like what I said, if the content is grainy or it is, not that great, then you need to reject it, and he has to rectify it within certain time. ऐसा नहीं कि आपने rectify किया वो 2 साल तक दिखाई नहीं आपको बाद में. So all these things are very important. So this is about the first part of the content distribution. Now we'll just talk about anti-piracy measures. So when we talk about anti-piracy, so first of all, what is the meaning of pirate? Can anyone tell me pirate कौन होता है? मतलब जो colloquial term है, traditional term क्या है pirate का? Who is a pirate? इसने pirate की story सुनी नहीं बचपन में? Okay, so traditionally a pirate is a person who used to commit acts of robbery on high seas. Okay. अभी ये term जो है वो content industry में भी आ गया है. This term has now permeated into the content industry also. So a pirate is basically a person, and I don't call them pirate, I call them parasites, because they are actually parasites. They feed on they cause benefit to themselves, but then they cause more harm to others, right? So these people are the people who actually promote the infringement of content, and they do it knowingly. So these are some of the measures we are going to talk about. So piracy, now your content can be acquired legally or illegally. Someone can sit in the theater and record the content, or someone can just purchase a CD and upload the content from the CD. So where he purchases the CD, he stores the content legally, but now he's doing an illegal act by distributing it. So how many of you, I mean, of course, I don't know how many of you would have known or seen movies on CD, but have you ever seen the jacket of a CD, or have you ever seen what is written on it? उस पर कुछ लिखा होता है. If you buy cinematograph films, जो फिल्म की CD लेते थे या सॉफ्टवेयर के आप CD लोगे, it is written on it, not for resale, only for non-commercial use. Why is that written? It is a requirement under the Copyright Act. It means that you can use it for non-commercial purpose. You can't make copies of the CD and start selling it. So that is very important. So anyways, coming back to the point, content can be acquired illegally or legally. The most importantly, person doesn't have the right to deal with the content being distributed. If you want to know more about infringement, please refer to Chapter 11, Section 51 of Copyright Act, and 52 also, because 52 tells you what is not infringement. Motive is to make commercial gains. Customers are attracted by giving them attractive offers. तुम 1000 रुपया, you are giving 1000 rupees subscription annually for one platform. For 5 platforms, 5000. I'll give you entire content for 1 year in 300 rupees. Consumer is happy. I'm making savings. Okay. The most importantly, efforts of creative persons are monetized without any benefit or rewards to them. And believe me, I've worked with creative people. When they come to know that they're so passionate about their work, they'll go to any extent to create the work. Like I know a producer who stays in Warsaw in Mumbai. That guy sold off his car, sold off his 2 flats to make the film. And when he came to know that his content was being pirated, he said, I'm going to kill myself. He was that disappointed. So, because these are sensitive people. People who create content are creative people, they are sensitive people. So, he told me कि मेहनत मैंने की, पैसा मैंने लगाया, and he was earning money out of it. Then we had to tell him that don't worry, we'll do something. But the point being that it affects them very badly. It affects, it's like, जैसे ऑफिस में आप काम करते हो, आपने मेहनत करके काम किया, आपका क्रेडिट किसी और ने ले लिया, यू विल फील इट, राइट? यार गलत हुआ मेरे साथ. So it's something like that. Now what is the impact of piracy? When you buy that content for 300 rupees, what happens? First of all, livelihood of creative persons is affected. Why livelihood is affected? They don't get remunerated for anything. There is loss of jobs in the entertainment industry. People say there's no point in putting money in production. It is not going to be protected. It is going to be pirated. Forget it. Don't make films. Loss of revenue to subscribe to. So subscribers are lost. Your OTT platforms, they lose subscribers. It's a loss of revenue. And the state, if you take subscriptions on a bona fide platform, the state gets GST. Here that is a loss to the state. Now why piracy is proliferated? Why do you think, what is the biggest reason for proliferation of piracy? If you ask me the biggest reason, and I'm not blaming it, but it's a fact, digitization of content. Content has become digital. Where you needed, if suppose earlier, you people had not even seen it, but if the reels which used to go in the theater, there used to be one big patrika peti. There used to be 6 circular boxes, each containing 2 reels of the film. It was this big, it was analog. Now you can put it in a pen drive. So it has become easy to store. It has become easy to access content. You use some hacking device, you download the entire film, the entire file of the film from an OTT platform. It has become very easy. See, it is always said that crooks are always two steps away of two steps ahead of the enforcement agencies. Whatever measures you deploy, these people will download the content. It has become easy because it is digital. And the distribution has become cheap. Earlier, if suppose you wanted to distribute a pirated book, you had to get the book printed, you had to get it xeroxed, someone had to stand outside the railway station, buy 500 का book 50 रुपए में ले लो करके. All that is not required. Just upload one PDF file. Book, millions of people can download it. Okay. One very big contributory factor is that our people don't know what is the impact of piracy, how it is harming the society and the economy. See, any right-thinking parent, if the child goes in a supermarket and picks up something and tries to walk out, he will say, no, keep it. He will not say, "Arey beta, very good, do more shoplifting." So same way, when he downloads the song, they don't tell him anything. हाँ, चल दिया ना गाना, चलो अच्छी बात है, very nice. But that is also kind of shoplifting. And lack of effective enforcement machinery. This is one thing which I have faced myself. So when I was working with Hungama, we were the exclusive licensee for T-Series, and there was some platform which was offering songs for streaming, T-Series songs. He had not taken a license from us. I went to the police station. So we were told, go and meet this officer in the detection department. So we had drafted a 10-page complaint with the annexures and everything. So I went to him. I said, "Sahib, sir, ye aap le lo or register my complaint and take action." So he said, he told me one thing very honestly. He says, last 30 years, I have been doing detection. But he said, I don't know what to do in cybercrime. I don't know what evidence is to be collected, how it is to be collected. So if a normal crime happens, he said, I know, I have to make a panchanama, I have to get 2 punches, I have to seal the article, I have to send it to forensic laboratory. He said, I don't know what to do. He says, can you help me technically? Then I had to call my technical people, they had to explain him what he was supposed to do. So this lack of enforcement is one of the biggest problems which is happening today. Okay. Now we come to an aggravated form of piracy, which is called as online piracy. And this online piracy has been compared by the courts to a mythological Greek serpent called Lernaean Hydra. You know what was the speciality of the Hydra? Anyone knows?
You chop off one head and multiple heads.
Yes. Yes. So the same thing happens with your online sites. You try to block one site, they will create mirror sites, redirects, whatnot, and the infringement will increase instead of going down. He will come with more menace. So there are some sites, which are flagrantly infringing online locations. The purpose of this site is only to commit infringement of content. They are set up for that business only. So this also has been recognized by the courts. Okay, like I said, if one URL is blocked, within minutes, URL with alphanumeric variations come up, like a Hydra, right? And to overcome this, the courts have come out with a remedy of dynamic injunction. We'll talk about that a little bit later, but just want to share some judicial observations on online piracy with you. So this is the High Court of Ireland judgment, where they have said that it ruins the ability of a generation of creative people in Ireland to establish a viable living. This is the impact which is recognized by the High Court of Ireland. Ruins the ability of a generation of creative people. In India, they say that the films available on CyberLocker website. CyberLocker also we are going to discuss. Just give me a minute. So they say that it can discourage legitimate distributors and content creators from investing in production and distribution of films. Like what I told you some time back, that if I'm not making revenue, why should I invest money in it? Now we come to this remedy of dynamic injunction. Let us understand why dynamic injunction is dynamic. Any idea why dynamic injunction is dynamic? So let me tell you this, that there are two things why this dynamic injunction is dynamic. The first thing is that the content industry itself is dynamic. And what do I mean by this? Fresh content is made every day. Example, TV serials, reality game shows, or OTT web series. Every day a new episode is released. So imagine you are a producer. You find episode number 1 of your serial is now being shown on an illegal site. You go to the High Court, you get an injunction. Okay. Next day, episode number 2 is shown. Will you again go to the High Court to get an injunction? So this is nature of the content industry is dynamic. But our pirates are also dynamic. What they do, I just told you. If you stop one website, they will come up with 3 other websites. So they are also dynamic. So our courts also had to become dynamic. So what they said, okay, we will give a dynamic injunction. All you need to do is, once the dynamic injunction is granted to you, it will cover your future content also. So it will cover your episode number 2, episode number 3, episode number 4 also. In case you see any infringement happening, just file an application supported by an affidavit and submit the evidence. The injunction will become effective. And you need not file it before the court. You can file it before the registrar. They have made it very simple. And immediately using that order, they can have that site blocked by the ISP or DNS, whatever. So that's why injunction is dynamic. So this is what I just told you. Plaintiffs will file an application supported by affidavit and evidence in respect of the copyrighted works, seeking extension of injunction to such websites. And injunction shall become operational against the said website and quash such works upon filing of the application, affidavit and evidence. Okay, so these are some legal views on dynamic injunction. The court has said that considering the nature of illegalities committed by the rogue website, giving it of dynamic injunction becomes necessary. Like, what is the nature of work? You stop one website, they will come up with other variations, but they will try to exploit it. Now, legal views on this is also another view. You can just read through it. There are some cases for reference. So in Applause got injunctions against Scam 1992. Star India got a dynamic injunction against illegal telecast of men's T20 World Cup. Against Star India got permanent injunction against illegal release and download of film Kalank. Now this is an interesting concept. This judgment has been passed in March 2024. Sorry. There is a concept of cyber lockers. Now what are cyber lockers? Cyber lockers are online platforms that encourage you to infringe copyright. You want me to close now? I can do that. Hey, I'll just run through this. Yeah, if you are running short of time, then or they can connect with me offline. If they want have any questions, they can approach me directly, no problem. I'll not take much of your time.
No, then we have 6 more minutes, sir. I thought let's take some questions.
Yeah. Cyber lockers. Okay, so this is a judgment, which they say is a technologically path-breaking judgment passed by Delhi High Court in March 2024. So what is a cyber locker? A cyber locker is an online platform which encourages you to infringe copyright. So suppose today I managed to get hold of a illegal copy of a film, infringing copy of a film. I upload it online. Every time a viewer sees or downloads that film, I get paid out. I means I the user. So this business model is made to infringe copyright. It is called a cyber locker. Distinguishing feature is it's a high capacity model. 500 GB to 10 TB. You can have 4K content uploaded. Okay. Revenue is generated through subscriptions and advertisements. Now, one more thing? One very interesting thing is, if you give a takedown notice, they will take down the content, but they will provide the user with the facility to upload content from another link. So they know what we are doing is wrong. They will say, okay, we have taken down. There's a takedown notice, we have complied with it. But they will allow user to generate another link and upload the content again. So this dynamic injunction was granted by Delhi High Court in Universal City Studios versus Mixed Drop. This is the case law. So those of you who are interested, you can download it from the Delhi High Court, read the order, very informative, very nice order. Okay, now this is a legislative measure. I'll just skip through this. So in order to prevent piracy, okay, in order to prevent a recording of content happening in the cinema halls, Cinematograph Act was amended on 31st July 2023, and it came into force on 4th August 2023. Okay, now what did this act do? It introduced Section 2DD, Section 6AA, Section 6AB, and Section 71A. So Section 2DD introduced the concept, whatever concept is existing of infringing copy in Copyright Act is now also introduced in the Cinematograph Amendment Act. Section 6AA makes it an offense to use any audio or audio-visual recording device to record the content in a cinema hall. So they have not used the word cinema hall, but they have used the word place licensed for exhibition of films, which obviously is a cinema hall. It can be an analog device, it can be a digital device. The purpose of the device may not be to just record, that doesn't matter. You cannot do it. Then Section 6BB provides that infringing copy cannot be used in any place not licensed for exhibition of film. So in other words, you can't use infringing copy for these video parlors and all, which are not licensed. And you cannot use that copy also in a way that amounts to infringement. So if you have procured an infringing copy from somewhere and you're offering it for commercial rental or reuse, it becomes an offense. And what is the punishment? Imprisonment of 3 months extending to 3 years, and fine starting from 3 lakh rupees up to 5% of the audited production cost. And the section provides that the other provisions of other act, the Copyright Act and the other acts, shall not be affected by this. Okay. Now this is just a technological measures. What can be done? There can be watermarking. There can be DRM. So we at UFO we use this technology. We encode the content whichever goes to the theaters. Unless there's a password called KDM, unless you use the KDM, you cannot play the show. Then there are online softwares, say spiders and crawlers to identify the pirated content. Now again, this is also not very accurate because sometimes notice also goes to the rightful right holders, and then there's a controversy. So we have faced this situation, we were the rightful licensees of some content, and we got a notice from iPlex claiming that you have violated the rights. He made a strike on our channel. We had to give a counter notice saying, boss, I am the rightful right holder. Please check your data. Please check your technology. Then labeling the content copyright notice. Then for putting up low resolution, low quality content for display. So if you're just displaying it, put up a low resolution content. And then having an access control system or conditional access system. Okay, these measures to combat piracy I have already spoken about, so I'm not repeating them in the interest of time. Thank you.
Thank you for that engaging and informative lecture, sir. I now call upon Mr. Hari S. Nair, Faculty Coordinator of the Nuals Alumni Association, to present a memento to Mr. Trivedi as a token of appreciation. On our behalf and on behalf of our sponsors, Advocate Karthik Ashok and Siddharth Baldev.
The paper presentations will start at 4:15. There is a slight delay. We are doing this so that, unlike yesterday, it doesn't run parallelly. So you will be able to attend all paper sessions and also this session. So that will probably start in another 45 minutes to 1 hour. So it's a slight delay.
Hello. 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 Check. Hello.
Good afternoon, ladies and gentlemen. It is my privilege to introduce our next session, a panel discussion on moral rights versus economic rights in copyright and trademark law, which is sponsored by Pritha Soman and Thomas George.
Allow me to introduce our distinguished panelists. First, we have Advocate Rajeshwari Hariharan, the founder of Rajeshwari and Associates, a leading IP law firm in New Delhi. With over 27 years of experience in intellectual property law, she's become a recognized authority in the field, particularly in patent litigation. Her achievements include securing India's first ever compulsory license for NATCO and successfully leading the landmark Glivec case, which set a critical precedent regarding the Section 3D of the Indian Patents Act. Beyond litigation, she has developed and managed patent portfolios for Indian and global clients, contributing to numerous patent oppositions and IP enforcement cases. Advocate Hariharan's contribution to IP law have earned her the titles of Trademark Star and Leading Patent Lawyer by prominent legal rankings such as the Managing IP and Chambers and Partners. We welcome you on stage, ma'am.
Next up, we have Advocate Sana Singh, Principal Associate at Indus Law. With nearly 8 years of professional experience, she has established herself as a leading figure in cross-border IP transactions and trademark prosecution. Ms. Singh advises both domestic and international businesses on various IP matters, including trademark filings, oppositions, and enforcement strategies. Her expertise extends to IP audits, technology transfer, licensing, and franchising. She is also involved in IP education, conducting training and awareness programs at notable institutions. Ms. Singh's work has been recognized by Legal 500 as a recommended lawyer and by IP Stars as a rising star in IP law. We welcome you onto stage, ma'am.
Joining them is Advocate Binoy Kadavan, a practicing lawyer in IPR law at the Kerala High Court. He is the youngest person to be nominated to the advisory panel on IPR by the Kerala State Council for Science and Environment. In this role, he plays a key part in shaping IPR policies and providing training in intellectual property law within Kerala, focusing on empowering local industries and educational institutions. We welcome you, sir.
Our discussion will be moderated by Dr. Nandita Narayan, Assistant Professor of Law at the National University of Advanced Legal Studies, Kochi. An alumnus of Nuals, she holds a PhD in philosophy focusing on artistic freedom. Dr. Narayan specializes in constitutional law, criminal law, and human rights. She has received several accolades for her academic excellence and currently teaches comparative constitutional law. We welcome you on the stage, ma'am.
Good afternoon, everyone. So we will keep this session as limited as possible, allowing the speakers ample amount of time at the same time. Each speaker will be given around 15 minutes to talk on this area, which is moral rights and economic rights in both copyright and trademark law. We will be looking into aspects of interplay between the two areas, conflicts, challenges, overlap, etc. So we have a brilliant panel here. I'll probably start with Rajeshwari ma'am. She will take us through moral rights in detail, and I will open the floor for questions once each speaker has spoken. So over to you, ma'am.
Thank you so much, Dr. Nandini. Thank you. Thank you, first of all, Nuals, for inviting me here. Great pleasure, great city, and great place. So today's topic here is about interplay between copyright and trademark and the moral rights in these areas. So before we go into what is the interplay and what is the impact of moral rights, we must first understand what really is moral rights. Where does it come from? What's the origin? So if you just trace back a few steps, moral rights has its origin in the history, in the European and the French history. So if you know, once upon a time, in the olden times, the French artists and the French creators used to make various kinds of articles. So if you see the French Venetian blinds, so they were all invented by the French. You know, those blinds which are painted. So they were created by the French. So they used to be created by can have moral rights in that. In trademarks, it's a little tricky. We'll come to trademarks in a bit, but just talking about copyright, there are 4 elements of the moral rights that an author has. First of all, when do these moral rights come into play? Moral rights will come into play after you have dealt with your work. So if you, for example, created a painting, and let's assume that you either assigned it or you gave it away, transferred your rights to some other entity. So maybe you assigned it to someone, you gave it to the government. So the ownership has actually transferred. Question is, do you still have any rights over it? So you made a painting, very nice painting, say of a tiger, and you gave it to the government to put it in so-and-so Vigyan Bhavan or in Kerala Bhavan or somewhere else. They put it there. This government loves tigers, they are promoting tigers, they are keeping it. The next government comes and says, what tiger? We shouldn't keep tigers. We should have maybe, our leaders, and we should have portraits of our leaders. And we don't want tigers. So then the question comes is, what do we do with those? Can the government just throw it away? And if the government does throw it away, does the author have any right to tell the governments, don't do that? Can the government say that, no, you've sold it to me, I will deal with it in the manner that I want to? So these are issues that arise. So this is the domain where moral rights come in. So now there are 4-5 elements of moral rights that arise. One is the right to integrity, in the sense that you have the right as an author to ensure that your work is integral, that the work is kept intact, is not mutilated, is not destroyed. So if the other artist, the assignee or the person who picks up your work maybe wants to destroy it because he doesn't need it anymore, then you have the right to control that. So that's one right. The other is the right to withdraw the work from the public. So this might seem quite funny, but yes, you do have a right to withdraw that work from the public. So the question is, how will you do it? I'm going to deal with it. I'm just making some points for you. And then comes the right of disclosure. How much should you disclose? In which aspects can you disclose is also your right. It is also your right to decide how many copies and where it should be disclosed, in what manner it should be made public. So these are different aspects, of your moral rights. Coming to the first one, where we say the right of attribute, this is another aspect is the right of attribution, which is why we say when, if someone has created a literary work and maybe you're using a table from that article, then you must give an attribution. You must say, yes, I picked up this table from so-and-so, maybe Aesop's et al., which is a article published by Aesop's in such and such journal. We always say that. So where does it come from? It comes from here because even though when you're writing an article for a journal and it is published in that journal, the author has the moral right to ensure that whenever anyone else is using an excerpt from it, he should be given credit for that. So now I'll give you some examples where authors have actually exercised their right, to be recognized. So you must have seen this movie which is called Tumbad. It's doing the rounds and it's quite popular now. There was a lady who wrote the dialogues and the screenplay for that. That was Miss Avnita Dutt. But she was never acknowledged in the movie as the dialogue writer. She wasn't acknowledged. So they went to court, and there were a lot of issues with regard to the contract. Ultimately, the court held that she should be recognized as the creator of the dialogues. So that's the right for you to be recognized, the right of attribution which I was talking about. So that's a right. Yet another case is, of course, the Manu Bhandari case. This was a case, there was a novelist. He wrote a story, Aapka Bunty. And then they tried to, make a movie out of it. And the movie was called Samay Ki Dhara. Samay Ki Dhara was the movie which they made. And the movie was entirely different. I mean, in the sense that though it had taken large portions from the story, it still did not depict it in that sense. So this author went to the court and they won. So these are all areas where, moral rights of an author have been recognized. Of course, you also have J.K. Rowling, who is very, very particular about how her Harry Potter series is used. I'll also talk about a couple of others. People who withdrew their rights, who withdrew their works from the market. So there was this author, who is Philip Pullman. He wrote this book, The Dark Materials. So that was a book all about, it's more on Marxist and socialist kind of principles. Eventually he started writing very different kind of books. And they were more modern and more forward-thinking, liberal-thinking kind of books. So he felt that his older books, like this Last Materials, with the Dark Materials which he has written, is not in sync with the newer books that he is writing. And he thought that people will, if they read that book and then they read this book, they will wonder how come I can have such kind of thoughts. So he withdrew it from the public. So it's a very pure incident, but yes, he withdrew it from the public. Similarly, you have others, like in the ancient times, you had this play which was written by Victor Hugo. He had a play, Les Miserables. And later on, because of the political climate which changed in France, so then he thought that this is not the way, we cannot have Les Miserables in public and we cannot have this play anymore. So that's why that play was withdrawn from the public. So those are all instances where moral rights were exercised and works were withdrawn from the public. Now, if you talk about trademarks, so trademarks is another area where really, no one recognizes moral rights in that sense. But yes, you will have rights over a trademark. So in what manner will it be exercised? What are those moral rights? If you are a owner of a trademark, I'm the owner of Godrej, for example, and maybe I have assigned my rights to another company. So it's the right of that company, I have assigned it to him, or if I've given it to him as a license, then what sort of rights do I have? So two rights particularly that you will have is the right to maintain control over the quality of the products, because what's a brand all about? The brand is about the name, the quality of the product. So it's your moral duty to ensure that the product's quality is maintained all the time. So which is why you have that moral right, and that's the reason why in most license agreements, this is an inevitable clause that the licensee will maintain the quality of the product. So that's one thing. And the second is to control your reputation. So this is, if you can understand this from a different perspective, there are companies, like let's take the example of Daewoo. Daewoo is a car which we all loved, but the company no longer exists. It ran into trouble and is no longer existing. So can you use that mark Daewoo and start a new business? Maybe you can use it for cars or for anything which is related to cars, or even not related to cars. Can you still use it? You can't. Daewoo can still come back and still argue in the court that I have a reputation and it is still in the minds of people. So I want to protect that reputation. So on those grounds, Daewoo can come back. Same way with Kingfisher. Even till today, we find that there are so many lawsuits which are filed by Kingfisher in order to protect its mark. So the right to protect your reputation in the market is something that can be considered as a moral right. There are companies that go into liquidation. Elder is a company which was in Bombay, and they went into liquidation. It's a pharmaceutical company. So their mark was being used by some other companies, to make their products and sell it in the market, because Elder is a very prominent, very attractive name. So people were using it for various products. The court came down heavily and gave injunction and injuncted those products which were using Elder's name. So even though the company was in liquidation, they were able to exercise this right. So this is these are the general rights that a person would have with regard to trademarks as well as copyright. So if you have any questions on that.
Thank you, ma'am. I think we'll move on to the next speaker, Binoy sir. He will take us through what are economic rights. So ma'am rightfully took us through what are moral rights, right to integrity, attribution, right to withdraw, right against mutilation, etc. Now hopefully sir will draw a picture for economic rights. So over to you.
A very warm good evening to all. Actually, it is a very proud moment for me, because this, I don't know whether the new students know me. I was a visiting faculty with Nuals and attending a seminar, and coming to this seminar as a panelist is a really honor for me. We were actually like a close family, because the institution was at its infancy and we were very small in numbers. So all the teachers, faculty members, even sub-staffs, we were all like a single family. So I used to say that that period of time is one of my moments in my life which I always like to keep close to my heart. I always share with my students also. So it is Indeed, a very proud moment for me. It's for thanks to all my students and also the organizers of the seminar for being part of this thing. So, as Madam has given a very nice elaboration about the moral rights of copyright as well as trademark, I've been interested to talk about the economic rights. So it is interested that everything, you know that a creative person, whether it is a writer, script writer, artist, every person, it was like if you look into some of the how does the statute and its nature changes actually. If you interestingly speak that initially the copyright was not identified to give what to say that, to recognize or remunerate the authors at all. Copyright, because earlier people used to write. Now, if you look into the history of copyright, you can see that the copying was done majorly in monasteries. They used to rewrite every prayers and all these things. Now, when you're asking a person to rewrite it, practically it is not possible to come in a very large volumes. So one point I just want to highlight this rights is copyright is very closely associated with technology. If you analyze the development of rights of copyright, it is connected with copyright, because if you look into the history of copyright, copyright got its prominence once the printing machine was invented. Till that time, nobody had time and took the pain to rewrite it possible. So this printing machine was invented, and it can be printed in so many number of copies. The demand for identification of the author was got into prominence. And if you look into the Statute of Anne, that was a historical first English act, and also the nature in which copyright was implemented is interesting to understand. Because the Queen of England, there were certain materials were circulated which was against the interest of Queen of England actually. So the Queen of England wanted to trace who has written that material which actually runs against her interest. So Queen of Interest brilliantly say that, okay, we are giving a recognition for that, but the ultimate interest was the Queen want to know who has published that interest. But you know that with the change of technology, with the printing press, it's got boom, and initially it started recognized actually. And if you look at the history, you know that Jonathan Swift, many famous writers actually died in penury. They were not having enough food to sustain themselves actually. So there was a lot of situations where in which these creative works were used in not only in their countries, in other foreign countries also, but no commercial gains. So there was a requirement from the UK as well as other countries, and with the development of the Berne Convention, if you look into the history of there was initial literary and artistic works were recognized not only in the regional wise but also in the international level. That they were identified that the work should be not only in the other countries also in a reciprocating manner, they should be able to identify. So if you look into the economic rights, the best example is if you see that J.K. Rowling. At one point of time, J.K. Rowling was one of the richest women in the world. She did not run any factory, she did not run any business. You know all about it. What she did was, Harry Potter, what happened to Harry Potter? Made into movie. So what she, as per the Copyright Act, that is, I'm coming to my point. You have certain statutory rights, particularly Indian law is concerned. Copyright, if you look into section 16 of the Copyright Act, it is very widely provided. For look at other acts and copyright, one of the major differences is that copyright is a self-contained legislation. It has all the civil remedies available in the Act. It has all the criminal remedies available in the Act. What are the rights in the Act? How does the copyright can be transferred? Everything is there in the Copyright Act itself. So it is very specifically when I teach, I'm just recollecting my days of teaching. One of the important thing is that it is a rights recognized by the statutes available to an author of literary, artistic, dramatic, musical works, cinematograph films, and sound recording. Oh, thank God, I recollected that whole definition. because very easy to remember. That is very any student can know, any exam. Copyright is a bundle of rights. That is very important. Copyright is a bundle of rights. That is, if you take section 14 of the Copyright Act, it provides a list of rights. That's be called as bundle of rights. Copyright is a bundle of rights recognized by the statute. Whatever is the act, that is there. You don't have anything more, you don't get anything less. So recognized by the statutes, given to an author. It is given to an author of a literary, dramatic, artistic, musical works, cinematograph films and sound recordings. That is the most simple, very simple definition of copyright. Any person, and you have to then, for an examination point of view also, you can just segregate into different things. So what are the economic rights? You can transfer these rights to any person. That is the most important aspect. So what are those rights? A person, just imagine, very simple, and I think the whole IP family, the copyright, learning copyright is very interesting because you learn about movies, you learn about novels, you learn about artistic things. You can slightly connected with that. Every day you come across either in the Bollywood or in the Hollywood characters, very interesting. So I always started my classes with copyright because people get attracted to the subject, then we move on to patents and all of the things actually. So what are the rights? For example, I am writing a story. Just for example, J.K. Rowling wrote a novel. Okay. She has a right of reproduction and distribution. That is rights vested with them. It is my sole right. Unless, the most important part is, unless I transfer it to another person, the right is vested with me. And if we look into section 18 of the Copyright Act, particularly dealing with assignment of copyright, there is no oral transfer. So actually, strictly speaking, you cannot, the opposite person or infringing person cannot escape, say that there was an understanding between the parties and I orally agreed to. Actually, that is not valid. It has to be signed by author or author's representative. So what I want is that economic rights, if you are transferring it, you are getting money. That is why it's called economic rights. Right of reproduction, the right of distribution, right of translation. Just take an example of J.K. Rowling. Translate into different languages. Right of adaptation. You can adapt into different, for example, drama or Amar Chitra Kada. Amar Chitra Kada is a good example of adaptation. You can convert into this different things actually. Right to make a cinematograph film. That is very important. So that is a major bundle of rights. That is very important. What is the nature of bundle of rights? Okay. Then the questions comes with the technological development. That is why he said all copyright is very closely connected with technology. Earlier it was printing press. Now particularly with the development of the digital technology, the issues may become very, very complex. Very complex. Particularly with the coming of AI, it has become more complex. Now it is you, the coming generation, has to resolve that issue. Who is the author? We say that copyright is available to an author, economic rights. Who is an author? Is it a machine? We are talking about a movie or a music, it is being developed by a machine. So who can be claimed as an author? So one of the important aspects which I want to say that these economic rights, reproduction, distribution, and other important aspect is that it can be segregated. That is very, very important. Segregated, what I mean is that is the scope of these rights actually. Because even now when we had discussions with clients, and our clients say that, okay, I've just given the rights to make a translation. You can give a one person's right to make a translation, one language to one person, and to the other language to another person. It is not like right to translation is a single right. No. You can break into whatever, into different phases you want. So that is the economic value of the rights you have under Copyright Act. That is very, very important actually. So that is many people actually lose. When you give an assignment agreement, that is the scope actually. People actually just not understand. They just, even into my clients actually, I don't know whether you know that. In Kerala, actually everything, not now, earlier period, everything was done by document writers. Any agreement, whether it is a film production agreement, whether it is all in, I don't know whether you know, document writers used to write that. So they know nothing, they don't know nothing about copyright. So they have never seen even the Copyright Act or nothing about that. So I used to mock at my clients, please just save them from the document writers and at least you make it written by some, because that is a major thing of all controversy. Because he does not know about assignment agreement, assignment deed, or what does the Copyright Act says about it. So when they talk about why I am talking about assignment even in the field of economic rights, because assignment has to be specific. If you look into section 18 of the Copyright Act, assignment has to be specific, which is a right you are transferring. And if your right you are transferring is not being specified, that right still rests with you. That is very, very important. So that is why you need to have a very clear understanding, knowing about what are the economic rights you have and how does the economic rights are getting transferred to other people. So what are the rights? It is, we call that as one point, this bundle of rights, we call it as residuary nature. Residuary rights means, you might have learned in the jurisprudence, residuary rights means you remain whatever, unless it is transferred, it is best with you. That still remains with you. You are the owner of all these rights, unless specifically transferred. And one point I just want to make you one point also. We have many people actually does not understand, particularly the film industry, even the right to make a cinematograph film. If you look into section 17 of the Copyright Act, we have a provision at the instance of a person for a valuable consideration, a cinematograph film made. Once a literary or musical work is done, the film person, the producer becomes the author of the owner of the copyright. You know who is the author of a cinematograph film? Or what is his creative input? Yeah, just, we can know what is his creative input. So I just wanted you to have an academic perspective to analyzing. We talk about intellectual property rights moving into an investment protection property rights. Indian copyright we take about, it is the producer is recognized as the author of the work. What is his creative contribution? Yesterday I had a discussion with SPEFCA writers, directors union as well as directors union actually. Both of them we want to have an agreement with the producers association actually. So they had brought a very Copyright Act with the directors union. I said your name is not there in the Copyright Act at all. After you talking about your rights, then they were shocked. Imagine when the authorities looking at the very higher pedestal like president and secretary does not know that, sir, is it true? I said take the Copyright Act, you read through it. If you can find out your name director there in the copyright, I will recognize you. No, just sharing with that. No, I'm not saying that whether it is bad or good, whatever it may be. So I was saying that, so that is why it is called economic rights. The intellectual property rights moving from protection of intellectual labor to an investment protection property. That is the most important aspect. And one point I just conclude with that. One point we can say that there is a Copyright Amendment Act came in 2002 and it was really, because at the instance of a valuable consideration, it was, if you remember, the final year students might have learned about IP, the IPRS versus Eastern Motion Pictures case. The court has said that once it is transferred, all the rights with the producer. So a lot of people, because because many other creative options now were available. Because it is not, even though I made a song for the movie, I had the option to put in the internet. Or in other words, where I can use that, actually. I had a real experience sharing with you. Fortunately or unfortunately, one of my clients' song, it's like a Mapla part, it was very popular in Kozhikode. It was first of its stuff, he made it actually. Fortunately, without his permission, I made the Vodafone actually give it as a ringtone. So we threatened with a notice of 10 lakhs. Finally, the matter got settled for 5 lakhs. He didn't expect that. Why I say that? You can say that what is a communication to the public actually? That is one of the most important rights available to an economic right. Communication to the public in different modes. YouTube channels, other social media, OTT platforms. Nowadays, just sharing with you, how does the OTT platforms, yesterday there was an interesting discussion. We talk about translation right and dubbing rights. Nowadays, what is happening? When a movie is released in the OTT, you are getting in Tamil, you are getting in Telugu, you are getting in Hindi, you are getting in all other languages. What is the right of remake you are talking about? You have a right of remake is there. But already and they are not being paid for that. So just sharing with you practical experience of economic rights with regard to that. And when you come to trademark is, that it is commerce, purely commerce. Trademark is one of the most important, even the people does not recognize. In Kerala, it is very, when I started my practice in Kerala, I used to wonder that. People are ready to spend crores for the advertisement. Even the company's clients spend more than 10 crores for advertisement, but does not want to spend even 2 to 3 lakhs for proper, application of trademark and proper monitoring of it. They simply said, what is the mark to be applied? How do your mark need to be protected? They are not worried about it. They are ready to spend crores, no problem. We had experience like that. Not even collecting the proper materials for a documentation. Spend a lot of money on advertising. Sir, we are advertising that paper, we are given that. Please bring the documents. No, that is not in our cases. We need that. Yeah, we'll conclude with that. Yeah, so I was just saying that trademark is, that, right, of getting named and the mark and
Does anyone have a question?
Hello, ma'am. This is Ravi Vyas. I have a question regarding if you heard the name of John Austin. And John Austin was died in 1834. And he was the professor in Oxford. When he was, I think, resigned due to some reason from the Oxford University. But you see, till 1830, and when 1834, when he was died, his work was not published. His work was published by his wife Sarah Taylor after 27 years, means 1861. So I have a question that what kind of rights Sarah Taylor have? Because John Austin was died. He don't know what rights.
Can you introduce yourself?
Myself?
Yes, Vyas.
Ravi Vyas.
Vyas, okay. Vyas, who is this question directed to? Anyone.
Either Hariharan ma'am or all the panels. And ma'am, I also have a second question I put. Another point is, there is a concept called honest and concurrent user. I think section 12 of Trademark Act. What that person can have a right, moral rights or economic rights? If he has a right, what kind of rights he has?
Okay, I'll address the second part. I will leave the first part to Binoy sir. As far as the honest concurrent user is concerned, there are several disclaimers with that. It does, when you say honest concurrent user, you have to first show that you bona fidely adopted the mark, that you are in different territories. Suppose you say, Meena Bhandar, and you are using it for sweets, and there's somebody in the south who's also saying Meena Bhandar and using it for sweets. Both of you started around the year 77. So you'll have to show that I bona fidely adopted Meena Bhandar because my wife's name is Beena. So that is what you have to establish. You don't get any moral rights in that. This is a statutory right. In trademark, as far as honest concurrent user is concerned, it's a statutory right. It's a defense that you can take. It is not a positive right. There is a difference between a defense that you can take and a positive right that you have. A positive right is your right to file the trademark. When somebody files a case against you and says, why are you using Meena Bhandar? Then you can take a defense and say, no, you must have started in 1977 in Kerala, but I'm using in UP in Haridwar, Meena Bhandar, because my wife's name is Meena, and for many years we've been using it. So that's a defense that you can take. It's not a positive right. So there's a difference in that. And it's a right given to you in law. This is a defense saying in law there are different differences that you can take when somebody files a case against you. Should have a right to say something. So this is one of the defenses. It's not like it's your positive right. So you don't go to the trademark registry and say that, you see, I'm a bona fide user, I'm an honest concurrent user, so give me a trademark. That is not what you do. It's a defense that you take. So there are no moral rights associated with that. The only right in that is to say that, well, I can protect the goodwill of my business, which I have been doing for the last so many years. And there are several conditions attached to it. So it's not randomly that you can just stand up and start saying I'm honest concurrent user. It comes with a heavy burden of proof.
Yeah, just adding on to that, and that is not a very easy burden to prove also, because you need to show enough materials to provide honest concurrent use with regard to that. That word itself gives an explanation. Honest concurrent. You are honest, you should be honest use, not by not wanted to use other person's reputation. Other person, it should be concurrent with the other person. You must be able to do in the same time. The main objective of that, for example, it may be possible, I am using a trademark here. I am using it in a genuine manner for the last 10 years. Other person has got a registration in UP or Delhi. How can I, a normal person, know about it actually? So that is a main purpose, to protect the honest people actually. Okay. And second one with regard to that, John Austin is question is only with regard to who is the author of the work. Yes. Yeah, his wife gets the author's copyright. Is most important aspect is that copyright, as far as Indian law or in UK law is concerned, copyright, the period of copyright is author's life plus 60 years. India is concerned. That is after the death. 60 years you get. So whatever rights provided under section 14 of the copyright, almost similar in UK also. Same rights is vested with the wife. The period starts from actually when the work is created, and author's life plus 60 years is the period of protection. So whether it is wife, whoever
right.
Yeah, inevitable right. So it is whoever published it, whatever it that, after that particular period goes to the public domain. That goes to the public domain because the rights need to be available to the public. And actually just sharing with that, copyright is not a right which is blocking it is a right which is for facilitating the creative freedom. That is why it is limited. Intellectual property is very important. After the period of protection, it goes to the public domain, and more creative works should come out of that. That is why we say that intellectual property always for a limited period. Okay.
Thank you, Vyas. I'll take 2 more questions, if there are any. Yes, please introduce yourself and then.
Ma'am, my name is Rebecca Sarajot. So I have a question regarding the AI. So that's for Sana Singh, ma'am. So, ma'am, right nowadays, if you see movies like Indian 2 or Fast and Furious, like main actors who were playing or portraying the characters, they use AI as an to portray the real characters, like Nedumani Venu and this guy named Vivek sir. So if we use this creative freedom for the what we say the writers like that or the directors, do you think there is like a over exploitation of this AI in the cinema field right now? Because the real character who have to play that, it's not using AI, so it's not the original acting which is they doing. So it's somebody else doing or portraying for them. So what is your opinion or viewpoint regarding that, ma'am? So do you think AI should be leading the film industry nowadays, or we don't need actors at all? So.
Thank you for the question. It's a debatable question. Like, we know that AI and the LLM space is being discussed about every day in and day out. But for your question first, on the copyright point of view, if the actors are giving the permission to use their personality rights in a particular manner by way of an AI tool, that is like a permissible use. This is first. And all these features like VFX, AI tools, and different features that are being used, this is done in order to enhance the commerciality and the commercial exploitation of that particular movie, yes. But till the time it's permissible, yes, it can fall under the ambit of non-infringement of copyright or any personality rights or any moral rights related to that particular actor. But leaving apart the copyrightability aspect and the fact that will AI take over the acting, see, originality is something that will still remain in content, and till the time the original content that exists and no AI tool can replace it, till that time I don't think there's going to be a like a complete no of the actors. But yes, this is more like a debatable question, and so if you'd like to add anything on this, or ma'am.
Yeah, I think it's quite fancy now to say that the role of one particular actor will be performed by using AI tools. But ultimately, we connect with people and we connect with emotions. Actors are people who sell emotions. So we want those real emotions. So I don't think, AI to some extent will entertain you. But will AI really replace you? I don't think so.
Just one question. As a lawyer, one interesting is, if Nadvadivani is no more, actually, the actress no more, who can give the right to recreate him? Who can give the right to give a personality, right? What is this? Even I don't want, I'm after my death, I don't want the AI to recreate myself and take a session like this. Even my children give a permission.
That's where the aspect of...
Yeah, just a lawyer perspective coming into that. No. Who is the right to give you need to give a permission. Who can give a permission actually?
Of course, the legal representatives can.
Yeah.
Like, in relation to the first question. Like similar to the first question, of course, the family members or the legal representatives can give the right. It's about the permission in the end. Because they do have the moral rights, they do have the economic rights akin to an author, but yes, till the 60 years. But the personality rights are something which will, it's still infinity.
It's a challenging also nowadays. Like the legal representatives also, there is a fight among the legal representatives whether they have to give that character.
Yes,
so that's another debate which is going on.
Yeah, that's a separate issue altogether.
Okay, I will take one last question. If there aren't any, I'm closing the floor.
Actually, I don't have a question, but I put some remarks one point. Ma'am, you talk about Less Miserable book, which is written by Victor Hugo. I think Victor Hugo is also a person who can establish the Berne Convention. Actually, ma'am, what I read in my past that through the Less Miserable book, there was a revolution came in our justice history. Yes, ma'am.
Why he had to withdraw that book?
That is the main question, ma'am, that I don't know. Because Less Miserable is the only book in the world who can create a revolution in the law field.
There was a political change in the atmosphere, and that's why he had to withdraw that book.
Because he was the victim in the particular book, that Vijay something name is there, and he tried to be an honest man. And through there is a story of love, justice, and sacrifice. Something is there.
So thank you. I'm closing the floor. I thank all the panelists. We had a wonderful session. In case you have any doubts or queries, you can take it to them after the session. Thank you once again.
Thank you to all our esteemed panelists for sharing such diverse and thoughtful perspectives on the challenges of media regulation and journalistic freedom. We truly appreciate the depth of this discussion.
Before we conclude, in recognition of our appreciation as well as our sponsors, Preeta Soman and Thomas George, I request our moderator, Dr. Nandita Narayan, to present the panelists with mementos. I now call upon our beloved alumni, Muthamani ma'am, to present a memento to Dr. Nandita ma'am as a token of appreciation.
participants, the paper presentation will begin at 4:30. There will be an attendance that
Hello. Hello. Check, check, check. Hello. Sound illalo. Check.
We are starting the next session shortly.
Hello, hello. Say. Hello.
Hello. Hello. Hello.
Good evening, everyone. It is my honor to introduce our next distinguished speaker, Advocate Shekhar Menon, a prominent figure in the fields of media and intellectual property law, for our next session. This session is kindly sponsored by Advocate Shilpa R. Shastri, Lead Counsel at ICICI Singapore, and Rakesh Warrior, Partner at JSA Advocates and Solicitors. Advocate Menon is the founder of Media Lexicon, a specialized media and entertainment law firm based in Mumbai, which he established in 2002. His career spans an impressive 3 decades, during which he has gained comprehensive exposure in legal, business, and strategic functions within the media and entertainment industry, copyright societies, and broadcasting organizations. Advocate Menon has built a reputation as a methodical advisor in cross-border intellectual property transactions. His expertise extends to negotiating complex new media contracts, sponsorship deals, financing agreements, and corporate taxation and compliance issues. Currently, Advocate Menon practices as an advocate at both the Bombay High Court and the Supreme Court of India. Ladies and gentlemen, please join me in welcoming to the stage a true luminary in the media and IP law, with a career spanning the entertainment industry, corporate boardrooms, and courtrooms across India, Advocate Shekhar Menon. Allow me to now introduce our moderator, Dr. Sandeep Emin, an alumna of Nuals. He is also an assistant professor at Nuals with an expertise in the areas of human rights law and terrorism law. With 2 LLMs from the Kochi University of Science and Technology and the University of Exeter, his experience in law and legal academia renders him perfect to moderate this interview session. Over to you, sir.
Good evening, sir. Good evening, everyone. Welcome to the fireside chat with Advocate Shekhar Menon, sir, who is the founder and senior partner of the firm Media Lexicon. It is generally said that the law embodies the story of a nation's development through many centuries. And if one needs to understand what law is, one needs to know what it was, what it is, and obviously what it tends to become. So let that be, sir, the first question of mine. We would obviously like to know what you were, what you are, and what's exactly your vision so far as your expertise is concerned, and possibly the progress of your firm Media Lexicon is concerned. And I'm asking you this particular question because of multiple reasons. One being, when I was going through the profile of the firm, I did find the fact that, of course, you are an IP and a media-based lawyer, media lawyer. And when I was going through the contents, I noticed the fact that the firm primarily, amongst many others, trust me when I say that, amongst many other laws, the primary areas that the firm covers is basically on media and entertainment laws. So I believe everybody here, as well as me, we would like to actually know, in terms of your progress post your LLB to where you're right now, what exactly do you actually mean by the term entertainment laws as well? And this question is also specific on account of the fact that your role was not just as a lawyer in the entire media industry. You also were an accomplished company secretary with Star India at one particular point of time for almost close to 8 to 9 years, if I'm correct. So please, sir.
Hello, able to listen? Good question he has asked, but I have to answer a lot of things, no? Since it's a somewhat nostalgia also, probably. But I want to be very clear with everyone. As such, in this country, beautiful India, we all make life by chance. not by choice. Those who want to be doctor, they have become engineer. And those who want to be lawyer, they are going to be, or they are some artistic work, or there's some actor. But so on and so forth. So my story also something like that. Everyone during studies, they used to want to study that time. Maybe 4 to 5 years. We'll do that, we'll do this, because we don't know where the journey is going to take. So this happened to me also when I was doing law. I was thought of doing a corporate lawyer. I think this has become a fashion that time too also, the corporate lawyer. But fact is that going to the corporate without a company secretary, no corporate will engage you. Because they also have that capital rationing to take best of the work from every people, no? Okay, so that way the company secretary came. Then of course the company secretary got into, then we got into the financial background. So that time, today also, if you are a CS, you get 50% exemptions. So I did my CWA also, but never practiced finance. I got lured to law. I really liked it. Now this, equipped with my studies as a lawyer, as a LLB, CS, CWA, not practicing, I landed in Bombay. So from where the journey started in 94, 95. So again I was lucky, by chance, I got a job in Star TV. But that time, if you would have been in Times of India and all, then would have been a best media lawyer or media house. Nobody knew about it. So even, it was not Star India, it was News Television India Private Limited or something. So, but they gave me good salary, I went. I'll be honest. And in the meantime, there was a appointment letter from that Reliance Infrastructure. So one of that company secretary said, why you are going into this night operators? We don't know who is that, TVs and all. It's a fact. We didn't know our internet to look into. So I said, you give me the money, I will come. He said, no, I will not. Wow. So from there, this journey started. I was also not knowing that I have joined such company. Later on, it was just a new company. It was nothing of Indian operations much. So, most important, first thing when I saw that, okay, we have to go for party. Wow, what kind of job it is. Yeah. So there, we got to know, yeah, so we are going to make big people. So again, by chance, I will put it again and again. So there, first it came, okay, where we are going? We are going to meet Amitabh Bachchan. Wow. We born and brought up watching his movie. I said, we're going to see. And that time, if I remember, there was a movie, Mrityu Datta. And what is to be done? The bus to be blasted. And that was the event show or something. Good work, no? Okay. But later on, we understood, oh no, it is a big, because the Indian operation started. Star Movie, Star Plus, Channel V, radios. By that time, there was a bubble of internet also. So it was so crazy. There I felt, oh wow, law is big. So this is where I start. When you talk about IP, or especially this copyright law, what is your raw material? It's document. Everything is in paper. Once you create something, when you say you are selling satellite rights, digital rights, terrestrial rights, theatrical rights, anything, it's all in document. So where the importance of the lawyers, I understood from there it starts. So when you say you have movie, no, but it's not a building. The valuations have gone more and more beyond our expectations. Previously, I think in 2000s and all, your movie will be what I made for 5-10 crores. And all these people will be paid hardly anything. Today you're talking about 500 crores. And some movie on South, I was understood that some movies coming for 1,000 crore project. Shakuni or something. Unbelievable. So what will be the monetizations of 60 years and going on? So here, sir, now comes the media, where I said that this is important. Now question is, what is this entertainment? Entertainment, we got this word from US, the entertainment attorneys. But there and here, entertainment is different. The first difference I found was in fashion. Abroad, fashion is not entertainment. But here, if you are a designer, it has to revolve around Bollywood-centric. You take any big fashion designers, they have the link with the Bollywood. Maybe Manish Malhotra, there's no harm in naming. He became big after Kuch Kuch Hota Hai. Or today also any movie comes, there will be some link. But today link maybe with Madras, with Chennai. But there, Louis Vuitton does not need your thing. They have their own way too. So that is why out of entertainment. Now entertainment law as such, we are very clear, film, music, television. Now OTT, OCC and all that has come. So that will remain as this thing. Now in a broader this thing, it's a media. Now, media, it is there because the broadcasters are there, the cable operators are there, the distribution mechanism is there. That's why it's a media, it's a big. So chiseling out, I'm very clear, where is this entertainment and where is this media? That's why it's media and entertainment. I started in 2002. Probably I'm the oldest media entertainment law firm. I was very clear I'm not going to do any other thing because itself is huge. Coming from theatrical to satellite to digital, now with AI and metaverse. Metaverse is going to be big. That will be my third curve. Now it is like at 2000, how we had digital. The same way I'm seeing the metaverse. It's in a very infant stage with technology development, but technology will never stop. After 10 years, metaverse will be, there is no need, we are all sitting here. All sitting at home, but the question is that I always wonder myself, then what we will do then? Anyhow, that is someday scary also. What will be after 25 years? There will be no teacher, there will be no judges, there will be no councils, what they will do after 50 years. Anyhow, wish you all the best. You should all witness what is going to be. So here, I am very clear. I hope I gave you some base to show that how it started and where we are now. And I hope, thanks for my anything you heard something wrong. Bye.
Thank you so much, sir. So I'll possibly frame my next question from the last set of sentences that you were just saying. In fact, in the 5-minute discussion that we had actually downstairs, you were actually talking about the same point wherein you were saying that it's almost possible that down the line, probably 10 or 15 years down the line, you may not even have law firms. So forget about having lawyers or counsels. So, and you said that you started the law firm in 2002. So I'm pretty much sure that probably when you started or possibly immediately before that, you were all dealing with paper-based contracts, right? And possibly a transition from that to contracts made through computers. We talk about them as e-contracts and all that. And now, what's your vision about how the firm is actually going to deal with contracts not through computers, but contracts by computers? What's your vision, please?
Hello. See, through computer, it's already started. Today, most of the execution of the documents are done by DGs, and it's accepted by law. So mechanism of end of the contract law is very clear, whereas the executions and the witnesses are there. That is being taken care, I feel, like electronically. It's much, much better than physical. So rather it will be going on with more clarity, with more photographs, with more of your this key notes, what's that? Key factors of giving your detailings and everything. So I'm not seeing any problem in that. It will be a norm. Rather, it will be faster. Now, saying that how people will go out from the background, that is the scary thing. Previously, making the document, you had some 10 people working. Now with this, it has come to 3 or 4. Now with more AI coming, and we are looking into, there is all redundant with, especially just beginning is ChatGPT. So all these things where we used to give it, okay, just please make it. Now you don't need it. So that particular space of that particular person is getting redundant. That is a scary thing. But as such, whenever technology does, there is some other way also comes which we cannot imagine. In 91, when the liberalization started, everyone was talking about the computers. Hue and cry in the parliament and across the street, just where the job will go, this thing. But that gave more importance to TCS and Infosys, and which we never expected. So this will also be giving some new energy sometime, which I may not be able to gauge it today.
Yes, sir. Thank you, sir. So, I had my own share of IPR classes during my LLB time, but then I still, not just that I consider, I am a novice in terms of IPR. So based on that, yesterday in the context of a discussion that actually happened as part of the conclave, and the speaker was not a lawyer. So he was, if I heard him correctly, the statement was that as a director, if you assign the rights to a producer, there are no rights that are left with the director. I wasn't sure as to whether that exactly is the legal regime behind that. So I wanted clarifications on that. And it's not just me. There were 2 specific questions by the audience, or from the audience, by the listeners, specifically on that particular part. So be it in the context of economical rights or moral rights, aren't there still rights that actually exist with the person who's already assigned the particular right? And the speaker was also trying to make a distinction between how this particular system works in the context of, or rather how this particular system works in Kerala, and there are a lot of distinction when the same system works in Mumbai. So I did not understand that part as well. So if you can throw some light on that, that would be helpful, sir.
First of all, I think till before pandemic. Now before pandemic is like BC and AD, you know, before Corona, BC, and then after Corona. Before that BC, everything was Bombay centric. And it has become a belief. And sometimes the belief goes to the reality. Now, why I said Bombay centric? Because it was like a big daddy. End of the day, copyright is a business law. Like how we have company law, we have compliance laws. No? When we talk about tax, there's a recovery law. But copyright is not recovery or compliance, it's a hardcore money law. Dhande ki baat kar. Now, I don't know, the regionals are on the belief that still Bombay is there. But it's not a fact. Today, regionals have their own films, own music, own news, own content. So they have to come out from the trauma that they were looked up low, now they are too big. First thing. So when you say Bombay, it happens or like that, it's nothing like that. Nothing is above law. It's up to the person that how he wants to spend the money and take to the court. You may write anything on this bilateral contract, and you know he is doing absolute nonsense. So I tell my client, please sign it, whatever he wants. Because that becomes easy for me to file it in the court and get an injunction. No? So here also, it's just a feeling which they have in Bombay. Yes, of course, there are many people are there, they say sign it, and people sign it in the stamp paper, they feel everything in life is gone. It's not like that, no. So I don't say ki whatever they feel, ki once they have signed, it is nothing like that. And question of moral right, moral right cannot be taken away, even after it is in public domain. And I think the best judgment was of Justice Rekha Mittal of Delhi High Court. I think it was in 2007 or something. Please read, go to the Google and Rekha Mittal. You will give a complete thing of the moral right. It's a Vigyan Bhavan's case here. You'll get a base of that.
Thanks a lot, sir. Thank you, sir. So, recently I've come across an article. It was kind of challenging things that are actually happening with certain states. For example, state of Tamil Nadu nationalizing certain artistic works which are older than the death of the author plus 60 years. They're nationalizing the works that are already there in the public domain. So could you please tell us why this particular discussion has happened now, or has these happened in the past as well? Is it just that persons like me are just coming to know this thing through newspapers right now? Things that are already there in the public domain, the government nationalizing it. So I do find that part as a problem. The second part of the problem that I thought about is the fact that, okay, you're nationalizing the work that is already there in the public domain, and you're giving so much and so much of money to the legal heirs as well. I'm not really sure as to whether that part is necessary also.
This is the usual question asked by every capitalist. I'm putting the money, why I'm giving it to them? ये जिंदगी में मरने के बाद भी मेरे से लेके जा रहा है, मैं तो मर जाऊंगा, all that. I said, yeah, you're right. But before that, let's have a understanding of this whole thing concept, where it started. Now, this is nothing new to the humankind. Nobody wants to give it to anyone. है ना, जो भी है तो उससे भी ले लो. This all started somewhere in 18th century, that's 1710 or something. No? So, India was never part of that. So 18th century, 19th century, 20th century. From the printing press till the author's fight, till is there. And it's an unending job for the lawyers. But that's a good news, no? So lawyers will always have the work for this. But now this public domain, after independence, India has just started into, okay, this otherwise, today Copyright Act, what we talk about, it's from 1911. And it got changed in 1914, pre-independence. Then after 1914, then it got into 1957. But I always wonder that there was a 58 Act was coming in UK. टेपा ही लगाना था, तो एक साल और रुक जाते. Which I don't have an answer for that. You take 1914 is equally fantastically written the same thing. उसमें से इन्होंने अपने remix किया है that had created a confusion and it landed into the court in 77 judgment. Because I don't know, some tweak was made on the cinematographic work. Otherwise it's exactly the same. The Britishers never got into the cinematographic work. No problem. Now, we have to understand, coming to the point you asked, sir, what is the base? The whole copyright law is always made on two premises. One is for authors and secondly for public. But unfortunately, since we are the kindergarten students of people who are understanding, both of them has not gone into the mind to give in to the authors and to the public. Still they are saying, ye maine banaya. It is not a Bisleri, my dear. That you sell it on your profit and you say it's my profit. That is why all this copyright is it's not an absolute right, it's an exclusive right. No rights are given in absoluteness. ठीक है, जिसने पैसा लगाया 60 साल तक एंजॉय कर, उसके बाद वो पब्लिक में चले जाता है, तो once it goes into the public, I feel that destiny has started. The destiny is not murdered here. So in my view, I may be wrong, I don't know, it is best any creativity comes when it goes back to the public. Now, public can also take it free and enjoy the creativeness of the person who has made it. It is not for the business. So what you have asked this public, this thing asking, it's just a new concept to the public. Once they will understand, but it goes to the court, we have a wonderful judgments, wonderful judges also who really get into this thing and saying that no dear, they will never support that. Yes, of course, without capitalist, you cannot run. But he's also given that time, no? 60 years is good. And when he can make his profit or whatever the ROE he wants to make it. So today you make anything, ROE is very clear. Yes, if you are looking for 2, 3 years, 4 years, it's a loss. But when you 60 years you are making, which we ourselves also don't know what is going to come, there is no loss. Now to substantiate that, everybody heard of Mera Naam Joker? Right. When Raj Kapoor made in mid-60s or somewhere, he never thought that there will be a terrestrial Doordarshan right will be coming. He never expected there will be video, there will be cable, there will be internet. So whatever money he has put, that's all ROA has given. So same is applicability to everyone. No? Today the problem is that multiple platforms and other things we are. Otherwise previously started with only theatrical rights. Till 77, the Doordarshan was not there. There only one revenue was there. And in that revenue, of course, they felt we have lost it, X amount invested, we are not able to. But they never expected the futuristic. Now all futuristic coming, I'm telling everyone, please be careful of your metaverse, which we had been telling in 2000, please take care of digitals. That time I was also not clear, but we were attending the seminars abroad, no? So they were telling this digital rights is going, abhi internet hai. Now everyone is signing internet right de do. Internet right is like electricity. तो कहते इलेक्ट्रिसिटी भी दे दो. अब इंटरनेट से तो सब कुछ चलता है. सेम वे इलेक्ट्रिसिटी से रेफ्रिजरेटर भी चलता है, कैमरा भी चलेगा, आपका म्यूजिक सिस्टम भी चलेगा. तो ऐसा नहीं होता. But this has to all tested before the court. People are just writing internet. You have taken all my life. Go and challenge. So you youngsters have a lot of job to go and challenge before the court. Applying your mind, go there and say this is a thing you want to. Right, sir? So your question is, again, I've answered, but it's very complicated questions you're asking.
Possibly maybe one or two questions from my end, and then we'll leave the floor open to questions from the audience as well.
Yeah.
So my next question would be, how do you see blockchain technologies reshaping the copyright laws in the country, and mostly in specific to royalties as well?
When you talk about blockchain technology, I think it will be more easy for the movies and songs or anything. When blockchain technology can be made for Visa and MasterCards, which in a second we don't know where all Visa Masters are being swapped. That also coming under blockchain. Now if I take movies, in total up till now, there will be not more than 20,000 movies are made in Hindi. Let's come into other regionals also. Now 20,000 movies, till 70s, mid 70s, there was only one right, that is theatrical rights. Then by that time, cable, video and all came. Now, for example, in one movie, we may talk any damn thing, there's not more than 10 rights. And the count of transactions for each movie will not be more than 20. So 20 into 10 rights, 200. 200 into 20,000. So if you go to any technology guy, sir, I'm having a 2 million transaction, he will say, yeah, better you go to other guy. TCS will not open the door also. So in blockchain technology, again, इतना है, उतना है, हमने document किया, what document किया, truck लेना पड़ेगा, क्यों भाई? In technology, nothing is impossible. First you realize it, but if government can start with GST, this is nothing for the government. The day when they will put a lens on these guys, I'm saying they will have a tough time. So total will not be more than 10 million. So 10 million transaction for any industry, I don't think so it's big. So there I scared what will happen. So its day is going to come, maybe after 5 to 10 years. I think blockchain technology will be very helpful that time, sir. And it can be done by this blockchain. But blockchain is also, will be out. There are more, this thing is coming. The technology is coming, which I found few of the scripts of the market, it has gone. I don't remember that. They're talking about that technology, which is 1,000 times faster than emails and other things. Yeah. So again, I will say Tom and Jerry. Legal is Tom and technology is Jerry. This show will go on like this.
Thanks, especially for the last analogy part as well. Sir, possibly the second last question of mine would be that we all are aware of the fact that you are an expert in cross-border IP transactions. So a novice or a person who is actually getting into a firm for the very first time, or possibly who has worked for like a couple of years, what are the actual challenges that the particular person may face in cross-border IP transactions issues in a law firm? What are the areas that the particular person should be aware of before dealing with a particular matter on cross-border IP transactions?
See, these cross-border transactions, I have to clear with three things. One is trademark, one is copyright, and one is patent. All the three have a different cross-border thing because of each one has its own process of registrations, process of monetizations, and the term which is there. As such, copyright is concerned, of course, registration is not there. So I'll stick into copyright only, because that itself is a different chapter of patent and this thing. Now, in the copyright, it's all started with the Berne Conventions and the treaties what we have. That is the first thing. But America, they had they will fiddle everywhere. And the transaction when we do with the dealing with the US, we have to be very careful. One thing is this, they were never, for 100 years, they were never the signatory of the Berne Convention. अब पूछो क्यों नहीं है बदमाशी है? अब हम as a transborder this thing, we'll say it's America, so we have to be careful because they have a different law, no? And out of 50 states, out of 20 have a different law. Like California is having different, New York is having different, Florida is having different. On the top, there's a Supreme Court decisions are there. So unless in this cross-border you engage of that particular lawyer on that particular jurisdiction, it's very difficult to understand each and every law. I'll be very honest, there will be no law firm doing cross-border transactions which will be sitting on his chair and say he is muddling his head. He will say, okay, fine, I'll engage the lawyer from there. We'll understand, of course, as a lawyer, we'll be taking care of the customer here, the client here. So any cross-border transactions, I will honestly say, to engage that particular jurisdiction's laws. And same way, why cross-border? I think internal border is also like that. If I want to do any cases in Kerala, you may be big in Delhi or Bombay. Who cares in here? But you need a local lawyer here who understand Delhi, goes to the court, and the honorable judges know, okay, I can trust these guys, otherwise these guys will go back. It will be a problem. So why cross-border only? Even domestic borders also, we have to engage the person of that jurisdiction.
So one last question from my end. Any particular lesson or philosophy or motto that has guided you throughout your professional life? Any specific philosophy that you believed in which ensured your success, and any particular set of skills that you may suggest to the lawyers to be the lawyers in future as well?
Yeah, it's a very interesting thing. What I found, everyone, whether you are doing bad or a good, even the local goon or anyone, what is the ingredient he asks? मेरे को ना trustworthy आदमी चाहिए. Wow. So means honesty and trust, irrespective of what you do in life, bad or good is a separate issue. This trust and honesty factor, is the most important thing. You may be doing as a friend also. The first factor which bonds you is the trust. Otherwise it ripples like anything. So my simple is that be transparent and be truthful, at least to whom you trust. That's whether it's your family, whether it's your brother, the sister, friends, everybody is searching for this ingredient only. Trust and honesty. जैसी निकला दोस्त गया भाड़ में.
So I'm sure that there are going to be more relevant questions from the audience side than the ones that I might have asked. So I think we'll set the floor open for questions, if any, from the audience side. I'm not really sure as to whether we do have time for all the questions to be asked. That largely depends on the time limit. But nevertheless, we'll try to accommodate almost all the questions. The one at the back first, followed by you, sir. The one at the back first.
Hello. Good evening, sir. The session was really insightful. Sir, myself, Jomi Joshi, I am a research scholar from Kochi University. Hello, sir. I am a research scholar from Kochi University, and my specialization is in the area of AI and IPR. The question I wanted to ask, sir, you had differentiated what is media, what is entertainment, and had mentioned that OTT platforms at the present scenario doesn't fall under any of it. But, sir, the youth or the present generation and probably the future generation is less lenient towards using television as a source of their entertainment. They mostly use social media or possibly OTT platforms. Right now, most of the television channels do have a particular OTT platform where they stream their products, like maybe serials or any of their shows and all. So, sir, is there a possible chance that in future the televisions and the broadcasting at present is gonna shift to a situation to include more social media, to include more OTT platforms? That was my first question. And a follow-on question is whether common people like us who use copyrighted songs for user-generated content like a music to create a reel, so does that require an assignment kind of thing in future, where every user-generated content include copyrighted material? That is my two questions.
This is the present question being asked everywhere. Now, it's a shift of the medium. That is from television to OTT. Now, more than OTT is the OCC. That is the curated content, which is the AI is picking up and making that. All this content, when you say assignment to be done, that will come before before we have to understand what is this content. Whether you are making the content for 2 minutes, 20 minutes, or 1 hour, whatever it may be. So when I see my mobile and anybody who send a WhatsApp, I say, wow, what a beautiful content they have made it. Now, there the content, when I'll say, what is the ingredient? First ingredient is the original literary music work has come. Again, I will take you to the law only. I am watching, but I am saying, okay, whatever the person has made it, first the thought has come in literary, and then the music, then the artistic works, and the dramatic works. Dramatic works, of course, is a screenplay. Let's understand that. Dramatic work is a screenplay. Your literary work is dialogues and the lyrics. Now this all become the underline. It goes inside the cinematograph film, which has a sound recording, which was records. Combined it is this thing. So your question I will ask, whatever people may be making in any content form, Section 2F of cinematograph film will operate first, which has inside everything all this. So your question, please, it's a good question for everyone. Everyone is asking, ki how does it? So for me, each and everything is monetizable, can be monetized. But whether the value is there or not, that's the market has to drive comment. Hope I made your answers clear. Questions? Okay.
Good evening, sir. Thank you so much for that insightful session. I have two questions. My first question is, how often as IP and media lawyer you see trademark cases coming to you? Because we have seen copyright having a lot of involvement in media, but then let's say Star or Disney having its trademark and that getting registered, if that sort of case coming. And secondly, what would be your advice to a young law students looking for a career in IP and media?
Now, as you said, IP and media. IP, as a beginning, I said there are three things, ingredients are there: patent, trademark, and copyright. And media is a consolidated this thing to what you say with the broadcastings and everything is coming. The laws are there. Now, when you say you want to be a trademark lawyer, copyright will come. Because when you go and ask for the trademark filing, they're asking for word, right? And they're asking for other than word. So when you make for word, and straight away it comes for your copyright also. When you go for trademark, the copyright is there, and they have to know. Similarly, anybody who is making any work in copyright, as a lawyer, you have to tell them, please read section 48. It's so clear, though it is not mandatory, but proof that prima facie is very clear. So which means if somebody has done a registration in copyright under section 48, the owners will become to the other person to prove. With the registrar giving that letter, whatever certificate, it is sufficient for the court to say giving an interim injunction. So as a lawyer, I will always say, please get everything registered, because section 48 says, though it is not mandatory. So evidences are very important, no? So there is a huge work for both TM and this thing, copyright. But we have to move beyond registrations also. Now, which I am seeing in regional things will come. The big money is not on registrations or contract. The The big money is on negotiations, the trading of the films and televisions. Now, you make a movie and you say the satellite rights to be sold, you're talking in crores. It's not 2 crores or 3 crores. They're talking 50 crores, 100 crores. So there, if you will get for your money for your what you're negotiating and you're doing your work. So all these rights where I'm seeing the big money is there. Registration is, of course, it will take care of your operational expenses. Of course, money is money. So you have to make a division doing only for registration. But as an owner, the prime thing is that what is happening on the deals. And then there you have a shift of non-lit and lit. So there are two divisions in any of the media entertainment. We have very clear, one is lit, litigations, and one is non-litigations. And non-litigations starts from there. No, you will never go to a client and say, you give me the work. You have to tell him you are losing money, you don't know how to make money. Then you say he'll be after you, he'll not get a sleep. That he's coming with something to say that, okay, there's a money part he's talking. Because that is the whole copyright, no? So that's your answer. I hope answer is correct. Anything more? I'm putting it very practically. You see, I'm not here. You are lawyers. You have read more. You're reading it more. I'm not giving the gyan of more of the sections and cases and all because you're really reading. Let's come into more practical aspects, no? So I'll love that questions. Tell me, sir.
Hello, sir. This is Ravi Vyas. Sir, I observed since yesterday that mostly presentations are on the copyrights. So I have one question that you are a panelist. The interview is going on. You speak something, and from that speaking, I am writing something. Can it is a copyright, or I am the owner of my writing? What you speak, and whatever you speak, I write that particular point. Can I have a ownership rights on that particular writing things? Second point, that when you give the example of US, I go through the case of Natco Pharma patent. You see the TRIPS agreement is created in favor of developing countries also. Developed countries have a lot of things, but as far as developing countries, they have lot of problems. So whether you think that TRIPS agreement is created in favor of developing countries, still there is a biasness going on with developing countries. I think Article 27 to 31 of the TRIPS agreement is totally focused on the patent. Along with, you see the Doha Declaration. There is a para 6, I think. Can you focus light on these kind of things?
Put it on two things you have asked. One is, I am saying something, you wrote it, whether you have a copyright or not.
Yes, yes, yes.
Second, I will come to the TRIPS also.
Yes, yes.
Right. Two questions, no?
Yes.
Great. Now, I am performing here, right? I am a performer. Now, performer, please read section 38. It is not a copyright. It is a special right granted by the statute. Okay. Now, the question is this, any speaker across this country, how they will monetize? If you want to sell somewhere, no, I have said something, you will sell somewhere. Then only worth noting it, no? Okay. Now there is a mechanism also. Now this special right, this performer, who are the performer then? You read the definition of performers. I don't remember section 2 something. Now performer is also a speaker. Name of speaker is also. But since we have that 1957 old beautiful archaic law, they have put the name snake charmer also. So we have to read that, but I don't have any concept how to get this snake charmer there. Yeah? And also conjurer. So I am in a much better level as a speaker. So you know what is conjurer? Conjurer who takes the evils from the somebody's spirit or something. I don't understand why, what is these guys are doing in the copyright. But it is there. So what you have asked me, whatever you have written, and if it is some different representation, you put it in this thing, I will come and sue you. And because I got the right from the sections, no? Right, sir? Now coming to second. Very interesting. Trip. No. Burn and trip. You only said all this for the developing nations. Now, please see who are the signatories of this trip. Even in developing nation also. First of all, somebody has to make a broad policy. But who is making the broad policy? There is a daddy. And that daddy is always US. Correct. अब उन्होंने कहा कि ये जो छोटे छोटे लोगों को इनका भी जरा कुछ भुगतान कर दो. But that is not a law. It's just a suggestion. When they come here, whether to make it implement in the parliament or not, that is the government's wish, no? Now, there are certain good things also. But here, when we come to our legislation, for every legislation, there is a central government. Right? ट्रिप ने तो कह दिया करने के लिए, but we have a different way of working. Now, for example, interest rate. I'll go beyond that, this thing why the trips it has come. Interest rate, in India, it is controlled by RBI. In America, the interest rate is controlled by the market. Now, we have a global auditing procedures, but I need not to follow that. We have to see what our law says. Their treatment of interest rate structures and depreciations are different, and in India it is different. So TRIP may be telling on their theory. So when it comes here, that becomes a different connotation altogether. And if there's somebody push also, you lawyers have a beautiful filer it, no? So if it is going beyond. So this TRIP, this thing, what you're saying, it is good and it is bad also. But we don't know what are the political, geopolitical going on to enforce to on us. This all depend on case-to-case basis when it comes. What exactly you want for that particular thing to be implemented or not. And how it affects my client or not. Am I right?
Sir, I think we have time only for one more question. So from, yes.
All right. Hello, sir. My name is Khushi Vinod. Oops, sorry. In a room full of people aspiring to be in the legal field, and based off of what you had shared about your apprehensions regarding technology and the metaverse, I think a practical question that I wanted to ask is, what is the scope of technology actually replacing our jobs as lawyers or in the legal field as such? Because the legal field has remained as analog as possible. So in the future, what exactly are your thoughts regarding this?
Nobody has seen the future. Right. But one thing I am sure, law firms will be robot driven. That you take it in writing from me. The reason, suppose you practice in X law, maybe company law, copyright law, what I mean. If I make copyright law, I don't have more than 1,000 questions. 1,000 questions is not more than. And then you have a AI algorithms also. So whoever across the globe want to ask me why I should have somebody or why I should sit. So you have to just put it, whoever gets into, the automatic questions will come. It's already we are seeing for other things. No, when Zomato can do it, why not we? And you don't have more than 1,000 questions. So then now your question is that what we will do, rather I am seeing that will be, turnover will be more. Today I say that I charge say X lakh rupees or something. Now if I have 10 millions into 500 rupees also per month, why I should bother for wasting my time and energy for them? So turnover is there. And the third question is that where you will sit, I will chill out in Mediterranean Sea. Because I don't have any job, because everybody is automated it has become. I have answered for your question. What we will do? That's a good question.
Owing an apology to everybody who still have questions to ask, but because we do not have too much of time left for this particular session, so it's time that we stop this particular session. But then, sir, thank you so much for this wonderful, informative session. It was an absolute privilege. Big round of applause, please. Big round of applause. Thank you so much, sir. Thanks a lot. Thanks a lot. Thank you so much. Thank you so much.
Thank you, sir, for your wonderful insights. I now request our moderator, Dr. Sandeep, to hand over the memento to Advocate Shekhar Menon as a token of our gratitude.
Nobody has seen the future.
Now, I request the faculty coordinator of Nuals Alumni Association, Hari sir, to hand over the memento to our moderator, Dr. Sandeep, as a token of our appreciation. Session of the day, which is an online session, which will be broadcasted.
Can give the introduction.
Ladies and gentlemen, it is my pleasure to welcome you all to the final session of the day, an engaging fireside chat with the esteemed Ms. N.D. Piper. The session is kindly sponsored by Ms. Ajita Pillai, Senior Counsel for a global company in the media and technology space. Ms. N.D. Piper is the General Counsel of the Spring Hill Company, a global consumer and entertainment enterprise where she oversees business and legal affairs across multiple brands. Her impressive career spans key roles at prominent media companies, including Complex Media, BuzzFeed, TV One, and Black Entertainment Television. A graduate of the University of Virginia with degrees in Spanish language and linguistics and law, Ms. Piper has further honed her expertise through Harvard's Cable Executive Management Program. She also serves on the board of the Black Entertainment and Sports Lawyers Association, underlining her commitment to legal education in the entertainment sector. Please join me in welcoming Ms. N.D. Piper. I am also delighted to introduce Advocate Ashwin Satish Nair, who will be moderating today's fireside chat. Advocate Ashwin is an associate partner at Media Lexicon, a leading law firm specializing in media and entertainment law. In addition to his role at Media Lexicon, he serves as the joint secretary of the Nuals Alumni Association, where he plays an active role in fostering the legal community and supporting the next generation of legal professionals. Please join me in welcoming Advocate Ashwin Satish Nair to guide us through this engaging discussion. On to you.
Hi, thank you so much, Devika, for that wonderful introduction. Ladies and gentlemen, the heartiest of welcomes to this session. We are here today live with Ms. N.D. Piper, General Counsel of the Spring Hill Company, USA. So without further ado, first of all, our heartfelt gratitude to you, ma'am, for joining us in this session. It's the second day of the International Conclave on Media and Entertainment Law happening here at the National University of Advanced Legal Studies. And hoping that there aren't any more obstacles or difficulties, let us move forward to the session, ma'am. So, N.D. ma'am, so the first question for you would be, is that your journey into the legal field is undoubtedly inspiring. Could you take us back to the beginning and share what motivated you to pursue law? Was there a defining moment or an experience that had led you to choose this path?
Yes. So first of all, it's good morning for me. Good evening to you all. Thank you so much for having me. I really appreciate this. It's very exciting to speak to people, lawyers or future lawyers and lawyers that want to work in the entertainment industry. We need as many people as we can because there's a lot of work to be done and a lot of content to be made. So this is very exciting. I did want to share that. I was in college or at university and really didn't know what I wanted to pursue next. I knew that my family expected me to get an advanced degree, but I didn't really know, what that looked like what was best for me. And I didn't have a lot of, I wasn't really pulled in a specific direction. I majored in Spanish, and I specifically majored in languages because that was what I liked the most in college. And I came from a family that was very much pursue what makes you happy. And so that's kind of why I majored in Spanish, because those were the courses that I enjoyed the most, and I really enjoyed Spanish literature. So post-college, I went to New York City, and I ended up getting a job at a law firm, Paul Weiss, Rifkin, Wharton, and Garrison. Paul Weiss now that's what it is for short in New York City. And I worked in litigation, and it wasn't the most enjoyable. I mean, I don't know if you all, these big law firms, they absolutely work you to death. So as a legal assistant or a paralegal, it was around the clock. I didn't sleep much, but I got to work on a lot of interesting cases. The first case that I worked on was a case where Billy Joel sued his manager, Frank Weber. And so I remember looking through the documents. I thought it was fascinating. So that's kind of where I started getting this idea that maybe this is something that I really would want to pursue long term. I also, in the evenings, because I was in New York City, I was kind of out in the social scene in New York, which New York does not sleep. And I was around a lot of creative people and a lot of people that were musicians, artists, all kinds of different people that wanted to be directors, working in film, writers, and a lot of them were very, very concerned about not really knowing how to move forward in their careers, not having proper guidance, or they were working with people that they thought were taking advantage of them. And I was like, I would really, that's where it kind of married. I was like, I think I would really like to maybe be a lawyer and work with creative and talented people, like all kinds. And so I thought, okay, I'm going to really pursue this law thing, make my family happy, and also make myself happy at the same time. And so I applied to law school. I really wanted to go to a top law school, and that's what I kind of knew in the United States. It kind of mattered where I went. And so I applied twice before I got in the third time to the University of Virginia. And particularly why I wanted to go to the University of Virginia was because it was a top 10 law school in the country, but it was also my state law school because I grew up in the state of Virginia. And so the fees were going to be far less. So I got in-state tuition, which was less than a third of what I would have paid if I was coming from another state. And so that was pretty much the best place for me to go. So finally I got in. I was very happy with my choice. The school was an amazing school, and it was a great place to learn.
Yes, ma'am. Thank you for that wonderful look into your early stages of your legal career, ma'am, leading to you joining into law school. Ma'am, speaking of law school, I believe every lawyer would have some sort of memories or some defining moments that they had in their academic life while they stood in law school, something that inspired them to go a certain way. And you mentioned about working with artists and things like that. Is there anything interesting about law school that you want to share with us, your experience going into law school? How different was it from your undergrad when you did Spanish, and how different the environment was and going into this entire ordeal?
It was absolutely crazy. I'm sure you all know it's very rigorous. I mean, it's a rigorous field of study. And so one of the reasons I really wanted to go to UVA, outside of me being able to go there, it being a top school and paying less to go there, was because at the time, so I'm much older, at the time it was the 90s, and there were two schools in the top 10 schools that had the best work-life balance, and they were Yale and UVA. Yale was number one. I did not believe that I was going to get into Yale. Now, in hindsight, I feel like I could have talked my way into Yale, but I didn't think that then. So in my mind, that's why I had to go there, because I really wanted to go to a school where there was work-life balance. I'm actually more of a creative person. And so I needed a place where there was going to be, freedom of thought, where people would sit around and talk about things. I wanted a more holistic, study of law, right? And I really thought that it was going to be provided for me there. And so I think when I got there, that's what it was. When I got to school, people were very serious about work, but they were also very serious about play. All of our, everyone that you took class with, which was called your section, the sections had softball teams. We played softball against each other. It was very much a collaborative learning space. And so that was what was very, very important to me. I think that what I got the most out of outside of class was just learning to listen to other people's opinions and why they had those opinions, which has helped me outside of class, outside of my practice of law, and inside the practice of law. Just being able to understand, okay, this is this person's viewpoint, this is why, and being able to listen to it, receive it, and also be able to, offer counterpoints for them to consider various things, but respecting everyone for their personal views. That's what I got the most, I think, out of it. In class, though, I'd say the best classes, I think, to take, or what you get the most from the classes, I'd say, I guess the same kind of thing in class, learning how to negotiate with people in class, bouncing ideas back and forth between each other. I just think it's a useful skill to have. It's just a useful skill to have in your life. So that's what I would say.
The process of ideating and brainstorming and figuring out a proper systematic solution to the issues at hand, if I may put it in different words, ma'am.
Yes.
Definitely, ma'am. And I really like the part where you talked about how law school broadens your mind and makes you listen to other people's view. And in a way, we can sort of say that law school weirdly unites people in a unique sort of way, whether it's through understanding each other or going through the same kind of rigorous curriculum together as well. And something that you mentioned that I really liked, and which will lead me to my next question, ma'am, is you mentioned that you like to have a creative environment, a collaborative environment. And this is something that in the short span, in the 2 days of the conclave that we've had, all the dignitaries who've spoken, something that I've noticed is that almost all of the people who are media entertainment lawyers or in this field, they have some sort of a creative element in their life, and the sort of way of fulfilling both the creative element and the subject they like and studied law is going into media entertainment law. So would you say that that is your case, and is that sound advice for someone who is feeling creative and doesn't know where they fit in within the different practice areas of law?
Yes. So, I mean, for me, my creative spaces, I do photography. I also play instruments, so that's my thing. I don't really draw as much as I used to, but I am a creative person, and I appreciate art, and I appreciate what other creative people do. What I will say is, it is the field in our country where the quirky people, this is the place for the quirky people. Like the people that are super smart, but also usually have a certain amount of, good social skills, and also can create, like they all tend to fall into this space because they all really care about the creation of, beautiful things and content. And so if you care about those things, if they matter to you, it's the type of thing where if you're going to study law, you kind of get pulled in that direction. And it's kind of like you find your people, and that's where they are. They're over there doing those things. It is a very fulfilling space if you're creative. It is very fulfilling because it's kind of like I'm able to marry, what I studied with what I love. And so it makes for a very passionate every day. Like I wake up every day very happy. Like even if it's stressful what I'm working on, I'm very happy that I'm forging, pushing something along that's going to contribute to the creative landscape. Like it just makes me feel good. And so I just think that that's really important.
Definitely, ma'am. And when you spoke about that, how all the quirky people are in this particular area of law, or people who want to do something in that area are choosing this. Another saying that goes around is the type of clients you have sort of mirrors the practice area that you're currently in. And speaking about the type of clients in the media entertainment industries, those are obviously celebrities and creatives and artists and entrepreneurs in that particular area. So the question is that, is there a particular skill set or anything you have to keep in mind strategy-wise when you're dealing with these people? Do you have to take a extra care on keeping things confidential, because obviously things that are known to these people are of public interest more than anything else, generally? Gossip, for lack of another word. And additionally, reputation management of these people also is something that I believe that might come into mind. And ma'am, could you just take us through the process of, what is unique to this particular clientele?
Yes. So the first big thing is we're all fans of something, right? But when you work in this space, you cannot be a fan. Or you can be a fan, but it needs to be private. Like it needs to be your own personal fandom, right? Because if you're a lawyer and you appear as a fan, people are not going to trust you. And you really want to be a trusted advisor. And the way to be a trusted advisor is to not treat celebrities like celebrity. You need to be able to center yourself so that you can connect with them on a human level as though they are any other human that needs advice and counsel. And so, this goes for everyone from celebrity to any kind of creative. They are people that are like spectacular humans, right? That's why they're in the spaces that they're in. So I would say the people I work with on a day-to-day, the producers, the writers, the graphic designers, they're all spectacular humans. Aside from the celebrities I've worked with, they're just spectacular. And you have to be able to kind of put yourself in their shoes, think about how they're receiving what you're saying, and tailor what you say, so that they can receive it well. I always think about, as lawyers, we go through school and, we speak lawyerly, very much legalese, that is not going to be received well by creative people because they don't know what you're talking about. And I learned this early on. It's like, we think that if we speak like that, they're going to think that we're smart and they're going to want us to be their lawyer. And that may be true for some, but after a while, that's going to get old. They need you to speak to them in plain English, like regular. I always say, like, how would I say this to my mom? And my mom is quite smart, by the way. But I'm just saying, she's not a lawyer. So I always think, how would I relay this to my mom so she absolutely understood, like, what I'm saying? And that's how I speak to my clients. And so, you just want to speak to them like they're normal people. I also think they kind of resent when you are a fan. Again, because they don't trust you, right? So that's kind of, I think, the main thing. You have to kind of keep that toned down and to a minimum. And it just makes for you being better able to serve your clients.
Exactly, ma'am. So professionalism and being professional to your client is a key part of being a media entertainment lawyer. And that doesn't necessarily mean that the clients might be professional all the time either, dealing with rock stars and movie stars. And one of the things that, yeah, exactly. So one of the things that I've heard from one of the speakers during a Q&A session was that a music lawyer said that you might you might have to be willing to even wake up at 11:30 at night from your sleep by an artist or a rapper calling you up and telling you, I've used the F word 16 times, does that make a difference? Or asking such trivial questions at weird times in the day, and they expect you to be there for them, because entertainment lawyers are not just legal advisors, but what's said is that they also double as managers, they double as marketers, they act as a connection point between other creatives to foster their collaborations as well. So ma'am, what do you say to that particular statement?
That is definitely correct. So if you're representing a human, their life is 24 hours a day, 7 days a week. And so yes, you are on call all the time. And if you do not want a life whereby you are accessible via your phone, then you should not do this. Like, it's not something for you. And I will say, I've worked in-house at companies. Entertainment is also 24 hours a day, 7 days a week. I am in Los Angeles now, but before I was on the East Coast in New York or in DC. And so, there might be a shoot at 11 o'clock at night, which in LA, if it's 11 o'clock in LA, it might be 2 in the morning on the East Coast, and I may get calls about things that are happening at the shoot. It's 24 hours a day. And you kind of have to train yourself to be, like, your ringer is always on, or you are able to wake up and be coherent quickly if you hear the buzz. Because I usually keep mine on just the buzz, the silent. But I am always accessible. I answer, my thing is, I'm going to answer an email within probably 3 to 4 hours. But if you contact me on my phone, I assume that's an emergency. And so I am always accessible, and I just think that it is something that you have to be willing to do, to be accessible. And also, yes, what the other person said about people asking you, like, random questions all the time. And you kind of have to be coherent in the middle of the night to answer these questions. Because I get these questions. I mean, at this current job, I don't get a lot of overnight because I'm on the West Coast. But I have worked, like I said, where I have people in LA and I'm on the East Coast at all hours of the night. So, I mean, it's just part of the job.
Yes, ma'am. And to have multiple time zones, clients working from different parts of the world, is to have a world clock running in your brain all the time. And I surely understand how difficult it must be. Even for the organization of this conclave, we had people from LA, London, Dubai joining in, and we had by-hearted the sort of international clock on how different it is from Indian Standard Time. So that must be a day-to-day job for you as well in doing this. And ma'am, you're currently the general counsel of the Spring Hill company, ma'am, and that is a company that is co-founded by the legendary basketball player Mr. LeBron James. So one question that I had in mind, ma'am, is that generally media companies are headed by MBAs or business majors, CEOs, all those things, and there are people who found their own companies. So working as a general counsel to a company that was creator-led or led by a celebrity, is there a difference in approach you have to take than, say, a very traditional corporate hierarchical structure or something of that sort?
Yeah, so he is the chairman of our board. The CEO of our company is Maverick Carter. And he is very much a highly respected business person here. But yes, when your company is started by a celebrity, I think there are certain things that go with that. The first big thing is, out of all of the celebrity companies that have done like things, I think our company has probably achieved the most to date. We have a very good reputation. We've made some amazing content. Emmy award-winning content. We've gotten a lot of awards. Things that are like, really have been really, really received well by consumers worldwide, as well as things that have been received well by the industry. So that's very good. But what I will say is, whenever our company does anything, people assume that the chairman of our board has done it, which I think it's very strange because clearly he's focused on basketball, unless it's the off season. But I mean, yeah, it's quite different to have someone's name attached to the company. As a lawyer, we're used to just, your job is to do risk assessments, shield the company from liability, the basic things you do when you work for a company. But it does make it, there's a heightened level when there's a human's name attached to the company. So, I mean, it's a day-to-day thing that has to be managed, but it is a little bit more heightened, especially for a company our size. I've worked at, our company is relatively small, less than 500. I've worked at other companies typically that are less than 500. And a lot of times you will take a little bit more risk because it's a smaller company. So we shy away from that a little bit because there are some higher stakes. So I will say that.
Definitely, ma'am, indeed. And yes, ma'am. And just like you said that it has a person's name attached as the face of the company, that sort of puts in a different image in the minds of the users who are interacting with that particular company or that conglomerate. Yes. And in the process of managing the legal affairs, obviously drafting contracts is a huge part of the work that we do as media entertainment lawyers. And like they say that anything is an art, drafting contracts is also an art, ma'am. What do you think? And is there even a possibility in the remote possibility in the future that entertainment lawyers, entertainment contracts become something that is awarded in the entertainment categories as well, perhaps in the Academy Awards, an award for best contract or the best contract?
Look, I would hope not. Because, we got to keep those things confidential. But I will tell you, it is really important. And as a skill, people need to really work on drafting. I mean, I've gotten some really, I just think that it's like a lost art. Like, people aren't as focused on drafting as they were 25 years ago. And I just really think it's something, like, if you're in school, you should be focused on making sure you know how to draft. You should be, and part of it is you may not get it in school. I don't know how you all's school works, but we did have contract drafting and negotiation in our law school, but it was only one class, and it's like the most important thing. And it's kind of like, I feel like you should be partnered with someone that is like a practicing professional to learn these things, someone that's a really good drafter, because what happens is people get out and you have to actually teach them from the bottom up. Like, a lot of times they don't have basic skill set in drafting. and I will admit it's something that I needed a lot of help with. And thankfully, the lawyers I worked for early on in my career were amazing drafters and took a lot of time with me to make sure my drafting was really good. But it is a thing. Like that's a huge thing. I will say too that being creative in drafting is amazing. Like that's where I think creative people really do well, is we can usually come up with really, really good deal structures. And if you can draft well, that, makes for, of course, a better deal. But I think you froze.
Good morning, ma'am. Ma'am, I'm facing a few technical issues. We'll be right back.
Okay. Can you hear me?
Hello. Yes, ma'am. We have a slight network issue here. I think now we are back online. Am I audible, ma'am? Is there any?
Yes, I can hear you. Yes.
Okay. Apologies for that little kerfuffle.
No worries.
So moving forward with that session, ma'am, as you said, practical training is really important for contracts, and I hope that a lot of sessions do happen in law schools to help bridge the gap between the industry as well as the learning phase of classes. And ma'am, the next question is, ma'am, you've had a long and illustrious career. Are there any sort of war stories or anecdotes or any particular moments that you want to share with our audience that might get them excited about a career in media and entertainment law, or get them an idea about what it really is like?
What I will say is I've worked in the industry for so many years that I've seen a lot. And the craziest things that I've experienced had nothing really to do with the practice of law. It's just part of being a part of the industry, right? But I mean, there are always stories. One of my most amazing things that happened to me, which I think I told you, you can't be a fan, but we really are fans, right? So when I worked at Black Entertainment Television, this is in like early 2000s, they all believed, you know, Indy essentially, she is not rattled by celebrities. She deals with celebrities every day. She does celebrity deals. So I think it was the second BET Awards. And I don't know if you all have access to see this award show, but it's like an amazing show featuring, it's like it's basically black music, which is basically here, it's pop music, it's pop culture award show. And so they made me the person responsible because the legal department was responsible for security at the award show. They made me responsible for determining who could go down the red carpet. So they put me at the front of the red carpet with a list. I had the names, and I'm just, you know, checking people off. And, you know, all these big celebrities were going down with their agents, managers, or publicists, or whoever. And I'm dating myself, but there's a group here called New Edition, who's like the original boy band, who I was a big fan of in the early 80s when I was a kid. And so 3 of the members were coming down the red carpet, and I had a small moment and had to excuse myself because I became a fan for a minute. So that, I will tell you though, I think it's hilarious because a few people have reminded me of that. Now, I didn't do anything crazy, of course, but I did have to excuse myself. And I had always said the only people I'm excited about are Prince, Michael Jackson, and New Edition. And other than that, everyone is the same. So that was my thing. I don't know, with respect to deals and things I've done, every single deal I do is very special to me. When I work on something and then I see the finished product, I get very, very happy, and it just warms my spirit. Like, I get very excited about it. And I mean, some of the things we have going on at Spring Hill now that I've been around since the beginning, we have a show called Starting 5 that's going to premiere on Netflix on October 9th, and it follows 5 players, including LeBron James, Jason Tatum. I don't know how big you all are into basketball, but it's a big deal here. 5 basketball stars through last season, the season 2023 into 2024. And it's like a really, really big deal. So I went to the premiere for that recently, and it just, I mean, I've been feeling so good about it, and it is premiering very soon. So like, those are the types of things that, like, you know, it just makes me happy. And I mean, I guess because I'm passionate about content. So yeah, it's a good thing. It's a good thing.
Definitely, ma'am, and thank you for that look into your life with the entertainment industry and as an entertainment lawyer. That was definitely inspiring for us, ma'am. And while we wind up towards our Q&A session, ma'am, one last question from my side would be, there is the concept of a 80-20 rule where it's like a small thing, something that might seem like an insignificant thing or a small skill is something that might help you do a majority of things, or learning something or becoming a different person in a certain way or a change in mindset, for a lack of better words, is something that might drive you or propel you exponentially forward from when the graph was like this to like this. So, ma'am, is there something that you could point out, any one thing or something that you could say as an advice to aspiring media entertainment lawyers that helped you actually go in an exponential path upwards on your career?
Yes. This has nothing to do with the law. This is about who you are as a person and how you engage with other people. You have to learn to network. And when I say learn to network, I mean like really, really network. So that means you need to be able to talk to people, every person, from the person that's the CEO down to the person cleaning the toilet. You need to be able to talk to every person, engage with them, make them feel like you are engaged and connected to them, and you need to be able to do that. And you need to know how to establish relationships, because this business is all about who you know. And you don't know who people are all the time. So you can't walk around thinking you're only going to talk to the most senior person. They're not, in most companies, they're not even the person that's controlling everything. You need to know the assistant, because you can't get on someone's calendar if you're not nice to the assistant, right? And so you just kind of have to think that. I also think here in the United States, I mean, I'm an African American. The person that is cleaning the office, you don't know who their niece or nephew is. It is, I mean, the way black families work, I mean, wealth is distributed in many ways. And so you need to understand that it's like about community and about you learning how to engage with all people. And once you get that and you learn how to like engage with people, you then need to learn, because this is the second part of networking, how to stay in touch with people and how to do it without being weird. Which means you want to contact people, but you don't want to email them every day. You want to send them an email. Once you meet someone, you want to set up based on them and how you think you connected with them, set up some kind of thing. I would put it on my calendar. You know, I'm going to check in with them once a quarter. Depending on what area they work in, maybe you see an article that might be interesting to them. Hey, saw this and thought of you, wanted to shoot it along. Maybe you ask them for coffee. I'd love to have coffee and just to learn more about what you do. Not asking for anything, but just saying, I'd just like to learn more, but not asking them to do something for you. These are the things you have to do so that when they know about an opportunity, you will be top of mind. And I mean, all of my jobs I've gotten because someone that I had networked with either told me about the job or said my name in a room. We're like, oh, you should talk to Indy Piper. These are the types of things that you want to happen. I mean, all this aside, you have to be an excellent lawyer as well. So you have to focus on that. But in order to function in the entertainment industry, you need the excellent lawyer part plus the networking part. And I think that, like, they don't really teach us in law school how to network. You're just kind of thrown out there. Everyone acts as though if you have really good grades, you're just going to get these great jobs, and you probably will, but they might not be the jobs you want all the time. And so, you know, you're going to have to work your way in by talking to people, engaging with all kinds of people, making sure that you're really like a people person, that you know how to connect with people. And another key thing is you need to connect other people. If you meet someone that you think, oh, they should know so-and-so, connect them. These are the types of things that you have to do to really succeed in the industry. All things that I do, that I learned. I was kind of already a connector to begin with from high school, college, because I just love people. But I really honed my skills once I got in the industry and realized, oh, this is what makes the world go round. Also, when you know all the people in the industry, it makes it so that your deals are easier. Like, most of the lawyers I do deals with, I'm not connecting with them for the first time. They know me. We've worked on something before, or we've met out, or we've been in the same circles. We know all the same people. That also makes it easy because you get on the phone and the first thing you do is say, oh, you know, how are you? Have you talked to so-and-so, our mutual friend, recently? Oh, yeah. Or it's, you know, oh, I see you're over at such and such. I know so-and-so. She works there. Oh, so-and-so is my friend. I'm like, yeah, you know. It just makes your negotiations easier when you've really done the work and you've really gotten out in the industry. The other thing, just one more thing about networking, you shouldn't just network with lawyers. That's not the goal here. The goal is to network with all people in the industry and all people otherwise. Like the people at the gas station, the people, these are all you don't know who they are. You should make sure they know who you are and what you do in a casual.
Definitely, ma'am.
Yeah, I mean, but it's crazy because people don't think this, and they think very, most lawyers are very type A, focused on doing good work. I mean, we've been pushed in a library, forced to read, study, work, and I think that all of us think, they try to make us think that our legal career is going to be like that. And honestly, it's not. Even at law firms, the people that are the best connectors, they're the ones that get all the clients. And no one teaches you how to do that. So it doesn't matter what area of the law you get into, you need to know how to work with people, all kinds of people. And you need to know how to make everyone feel comfortable. You need to be able to connect with them. You need to be likable. And it's a skill set, a big one.
Definitely, ma'am. And thank you so much. When I asked you to say just one word, you said the one word and you took it 3 steps further, explaining it. Everyone tells you as generic career advice to network, but you took it further by saying that networking doesn't mean just going to people with an agenda. It's not. Sometimes the best connections might come from speaking to people without having an agenda in mind to particularly network. Exactly. And moving forward and putting up calendar dates to keep in touch with people is something that not many people think about. It's like, I'll see you when I see you. Instead of that, you have to make an effort to actually keep in touch while not being creepy and too overbearing on them as well, ma'am. So thank you so much for taking that forth and teaching us how to actually get into networking and do it in a professional manner as well, and how it will benefit you as understanding and knowing the people in the industry is not just good for business, but good for closing deals, as the other person on the other side of the aisle or the other side of the table, who's not just a stranger or an opposing lawyer, but it's also a friend or an acquaintance of yours or a colleague of yours. So shall we head into the Q&A session?
Yes.
Okay. Ma'am, is it visible, the screen?
Oh, yeah, I can see it.
Yes, ma'am. So I'll just read out the questions one by one. So, ma'am, the first question is, since entertainment law is so tied to the creative avenues of the lawyers, does this not heighten chances for personal bias to creep into the way in which these lawyers are working?
Yeah, I mean, you bring who you are to your practice of law, right? I mean, we all do that. But you have to be aware that everything's not about you. Just like I said about what we learn in law school, I think we all learn that everyone has a point of view. And we all learn that we have to take their point of view serious, and you need to learn how to absorb that and try to figure out where it came from and why they feel that way. And so I think you take it, you bring who you are to your practice, but you also learn about others and bring that into your practice as well. And you should be trying to function in a way that is not biased. That should be your goal, right? That's how you should be functioning. Yeah.
So the next question is, when working with sports persons, how often do you find yourself stuck in situations where the right legal action is the opposite of what the client wants? What do you do in those situations?
Well, I haven't experienced this with the chairman of my board, just because I'm functioning on the entertainment side. But dealing with just at work and working at entertainment companies in general, there are legal decisions and business decisions, right? And so if someone is the CEO of a company, or if someone is working at a company and I am the general counsel, and everyone on my team, the lawyers, our job is to advise. That's our job. There are times, however, that the business will make a decision to take the risk and to go against your advice and counsel, and that's fine, right? The idea, though, is they have to understand what the consequences are. And so typically, when I'm in a scenario where I advise, let's say, someone creative on a team, and this has been going on since the beginning of my career, if I advise you, hey, I don't think you should do X. Typically, I'm not going to say you shouldn't do it without following with, why not try it this way? Try Y. So that's point one. You always want to provide people with an alternative that will get them to where they want to go, but decrease the risk. So that's number one. If they still don't want to do that and they want to do it their way, there are times where you have to escalate it to who the prime business decision maker is at the company, which is, look, if the CEO decides they're cool with you doing it, then that's fine. And then I'm fine with that as counsel. The only thing I'm not going to bend on is something that's illegal, of course, but I haven't encountered those things yet. But things that are business decisions and that are high risk, that's fine for a CEO to make and for them to go against my counsel. I'm thinking in my career, maybe that's happened one time. And it wasn't even a super rare.
Yes, ma'am. So the next question is, art is an expression, so is creativity. Often laws just talk about rights, stakeholders talk about rights, etc. But what do you think the artists want? Would they want to be constrained by regulation?
Well, this is the thing. A lot of the regulation protects them. So, yeah, what they want is they want to be able to create what they want, and they want to own it. Generally, that's what creative people want. They don't want you to be able to use it without their permission. They're not talking about it in those terms, but it's theirs. I just think that that's kind of like what they all want. Regulation, I think, is the artist's friend, though, to some degree. Now, I don't know about regulation in your country, but here, it has traditionally been protective of artists' rights. There has been some, softening of that, which is allowing people that do derivative works, to have some ability to do derivative works as well. And so that means they're not protecting everything that you have if someone else can make a derivative and it's fine. So it's kind of, these are the things that are being discussed, but I think most creative people appreciate some amount of protection for for what they create.
Definitely, ma'am. That is a one-line answer to what artists want. Is they want to they want to create things freely, and they want to own what they create.
Yes.
The next question is: do people of color face any discrimination despite their expertise and knowledge? And I think this ties into several other panels that you've spoken into as well, ma'am.
Yes, definitely. I mean, racism is a real thing. It exists. And so I think for me as a woman of color, because there's a lot of types of discrimination, I have to be extremely excellent at what I do, and I still face issues. Fortunately for me, I've been afforded the ability to work at companies that accepted me for who I am and that appreciate the fact that I'm a woman and appreciate the fact that I'm a person of color. But I'm sure there are instances where that doesn't happen. And I mean, I have a lot of friends in the industry that have not had, the same type of situations in the workplace. What I do believe, though, is that, if you find yourself in this type of space, well, first off, I don't think you should avoid certain spaces because you feel like you're going to be discriminated against. Traditionally in the United States, there are places where people of color have been excluded. And the idea is we need to break those barriers. So my thing is, if they don't want you there, you should still go there. And it might be challenging, but I just feel like it's the type of thing where you have to break the barrier. You have to shatter the glass ceiling. You have to do it. And so a lot of times people are in situations that are very difficult, but I do think that there's value in that. And I think when you're excellent and you get in spaces where you're not wanted, you do teach them in some way that, hey, people that look like me can do this. We are excellent at our jobs. And I think it starts to change the narrative. So I'm definitely a proponent of going into spaces where we're not wanted. And I also think that if you're in a space where it's unbearable, at a certain point, you should probably leave. But I do appreciate the breaking the barriers part, though.
Definitely, ma'am. A very insightful answer to that particular question. And I think this is our last question here, and it sort of ties into the topic about networking that you mentioned, ma'am. Other than the tips that you mentioned, are there anything else that you can say for aspiring media entertainment lawyers on how to network, any do's and don'ts in particular that you might be able to provide for us?
You mean like networking specific, though?
Networking specific, ma'am.
Oh, goodness. Do's and don'ts. The first, I mean, I can give a list of I can talk about that all day. First of all, you should go to every single event that you can go to, be it a reception, a conference, any place where you think people in entertainment and media are going, lawyers or otherwise, you should go. You should go and you should talk to people. And it doesn't mean that you don't push yourself on people, but go as yourself and engage with people. Number two, you have to have a little bit of an elevator pitch, a way to describe you and what you do and who you are, and you should have different versions of that. So if I'm at a cocktail reception and it's not entertainment related, you know, people ask me what I do. I say, oh, I work in media or I work in entertainment. Yeah, you know, I have a little something that I say, right? But if I'm at an entertainment media thing, it's a little different. I will add a little more color. Oh, yes, I work at Spring Hill. Everyone in the industry knows what Spring Hill is. So they're like, oh, great. And it starts a conversation. I wouldn't necessarily mention that at a non-media entertainment event. But I have little things that I will say that I am prepped to talk about myself, and I'm always prepared to exchange information. And if you're not comfortable giving your number or email to people, you kind of are going to have to get comfortable doing that because that's a part of the industry. So you should have, like, people use business cards, but that has kind of gone away. My company doesn't even give business cards anymore. We all use digital cards. And so I have a digital card where, you know, you scan with your phone and take people's information, and I give that out freely. There are thousands of people.
A QR code or an NFC-enabled card.
Yes.
Sorts.
And there are thousands of people that have access to this phone because I've had the same phone number since the late 90s, and it's been on business cards, and you know, I've been giving it out for years. But the thing is, I'm comfortable with that. And I think that people will be respectful of your number and your email. But I do think you have to be comfortable with giving it out. I also think that depending on what you do, if you're going to go into a firm, you need to make sure that people know what your practice area is. So if it's like, hey, I work in this, you need to learn how to explain what you do to the average person so that if they hear someone talking about they need help with this, that person will know, oh, well, let me call Indy because this is what Indy does. So you need to do that if you're going into a firm. If you're working in-house, I think that the primary thing is you just want people to know that you work in-house, and if you have a specialty area, kind of what that is as well. I can't take on clients outside of my company, but people do call me frequently and want to just know general things, and I'll tell them, and I'm very open with this. I'm like, look, I cannot represent you because I work for this company. However, I can give you some general guidelines or tell you some general things I know about what you're asking. So if it's someone that's calling to ask about maybe they're producing a film, like what should they be thinking about? I will tell them these things, but I make it clear to them, I cannot represent you, but I'll give them a little film 101, if you will. And I am very open with this type of information, which is why I have a good reputation, because there are all these people walking around that say, Indy helped me. when I had questions and I didn't know who to go to, she helped me. And I always, also because I work in-house, I always have lawyers at law firms in my brain that I will refer people to based on what they need. And so that also builds goodwill with the lawyers at the firm. So when I have to negotiate against them, because they represent a lot of people, they're always very kind to me because I sent them business like 3 months ago. And so that's like kind of the cycle of how you network with these folks.
Definitely, ma'am. It's about knowing your audience and not throwing a bombardment of information at one person, but putting out what is relevant to them and helping them out, and even helping people and advising people free of charge from time to time might not benefit you immediately, but it might come around again back to you in some form or the other, as goodwill is definitely an important part of being an advisor, a trusted advisor, that is, ma'am. And that brings us to the end of our session today, ma'am. Thank you so much for agreeing to come with us. I hope you enjoyed this particular conversation as much as I and the audience have enjoyed this conversation, and hopefully we hope to host you here in person at the campus in Kochi sometime in the future as well, if that is something of interest to you. And
of course. Thank you so much. I appreciate you all having me. And good luck to the students. Good luck to the practicing lawyers. Keep networking. Students, it's not too early to start networking, so start now. But thank you. I really appreciate the time today.
As we conclude this enriching fireside chat, I would like to extend my heartfelt thanks to Ms. Indy Piper for sharing her valuable insights with us today. Your perspectives have truly deepened our understanding of all aspects surrounding the legal field and provided more food for thought. A special thank you to Advocate Ashwin Satish Nair for skillfully moderating the session and guiding the discussion with such expertise. I extend my gratitude once again to Ms. Ajita Pillai, Senior Counsel for a global company in the media and technology space, for sponsoring and making this session possible. Thank you, ma'am, once again, and thank you all for your participation and engagement throughout the day. Wishing you all a wonderful evening and a good night. We look forward to seeing you tomorrow.
Thank you.
Thank you, ma'am. Bye.